to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Many of you have been with us before and have heard the familiar announcements, but please just remember not to bring any food or beverage other than water. Please silence your cell phones, and if you are speaking publicly to the commission, we ask that you speak loudly so that our recording equipment captures your statements. I do want to let you know that in a few minutes you'll see our newest commissioner, Ashley Kuhn, slip in, so don't be surprised. This was her first meeting, and she didn't make it in the most direct route to the first DCA, but she'll be here very shortly. But I think that we can proceed now with the approval of the minutes. I'd entertain a motion to approve the meeting minutes of January 19th.
Motion.
Second.
Moved and seconded. Is there any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? The minutes are approved. We are going to take a little detour in our agenda to start off with so that we can accommodate the schedules of some of the others that are present for this item. And if there's no objection from the commission, we will move the matter involving Ken Hagan's petition for attorney's fees, item 15-215, if I read that correctly, to the beginning. So I'll give everybody a second to catch up to item 6A in your agenda. Do we have any handouts in this matter?
Madam Chair, we received correspondence from the complainant, I think the day before yesterday. We have copies of it. As you'll recall from last meeting, we had late filed documents. Our rules don't provide for that. But if any member of the commission wants to receive those documents, they can request it, and we do have copies.
Let me just, by way of background, remind everyone, this attorney's fees case filed by Mr. Ken Hagan was the respondent in complaint number 15-215. Mr. Hagan's petition seeks to have the complainant, Mr. George Neiman, pay attorney's fees and costs following the dismissal of the complaint against Mr. Hagan. At the last meeting, you will recall the petition was dismissed as legally insufficient with leave to amend, and today we have before us the amended petition. So just recall that at this stage, if the petition is denied, the case will be dismissed. If the petition is not denied, the matter will proceed to the Division of Administrative Hearings for a hearing. Are either Mr. Hagan or Mr. Neiman or their counsel present? Thank you. Anyone else present in this matter? We have copies of the file and of the staff's draft of an order dismissing Mr. Hagan's amended petition as legally sufficient. As Ms. Doss explained, we do have other correspondence, but hearing no request for it, we will not entertain that. Yes, Mr. Cox.
I would like to see it.
Okay. Is there any discussion? Mr. Cox has basically asked. I don't think it
Yes,
needs to be in the
please.
form of a motion.
Pretty please.
2 pretty pleases is enough. Any discussion on that? Hearing no objection, then would you please proceed with passing out the material? Before you take a look at this, can I ask you to just, like your children, turn around, put your paper down, and Mr. Schaefer, is there anything that you want to say about this document before we proceed?
No, I think it speaks for itself.
Okay, thank you. You may turn your paper over. Mr. Schaefer is going to summarize the staff recommendation on the petition after you've had a chance to review this. Then we will hear from Mr. Levine, followed, but I don't think there is anyone here on behalf of the complainant. The parties, as you know, Mr. Levine, we'd ask you to limit your remarks to 15 minutes, and after that, the commission members are free to ask questions. So we'll take a few minutes on this document. Mr. Schaefer, you ready to proceed?
Yes, thank you, Chair. In my opinion, this amended petition brings nothing substantive to adequately plead the elements of the fees and costs statute. I am recommending that it be dismissed. I just want to briefly review that statute with you. It's found in section 112.317, subsection 7, and it's very specific about the circumstances where fees and costs can be awarded. Requires the party petitioning for fees to allege these elements in their petition for you to send it to DOA. First, that the complaint contains false allegations. Second, that the false allegations concern material facts. And third, that the false allegations were made either knowingly or recklessly at the time the complaint was filed. I'd like to briefly walk you through my analysis of the arguments in the amended petition, but I first want to just make some general background comments on this statute. It's a very exacting law. The legislature intended it to be difficult for an ethics respondent to obtain fees, and that's why the statute contains elements that are so challenging to allege and then to prove. And the reason for that is you don't want to chill potential complainants from bringing ethics complaints based on the fear that if during the ethics investigation their allegations are found to be false, that they'll have to go through a very costly DOA trial on fees. The fee statute needs to be strictly construed, frankly, so that people across the state are not frightened to file ethics complaints before you. And because of that, it's not surprising that it's so rare for you to actually send a fees petition to DOA. It happens. It's happened recently, but it is rare. Now here, according to the amended petition, Mr. Neiman, the complainant, brought his complaint based on information that he learned from an investigative journalist working for a television station in the Tampa area who was covering a story on Commissioner Hagan. The amended petition alleges that information was credible enough to spark an exhaustive criminal investigation based on those same allegations for multiple law enforcement agencies in the Tampa area. Now, I think you should just consider that the allegations are based on information from a credible investigative journalist and that they were credible enough to spark a major law enforcement investigation when you're weighing whether Mr. Neiman was reckless in bringing the complaint. Now, if you look at the content, the arguments of the amended petition, even accepting them all as true, I don't believe they demonstrate Mr. Neiman brought the complaint knowing it contained false allegations or with a reckless disregard as to whether it did, which is an essential element of the fees and costs statute. The first argument is that Mr. Neiman based the content in his complaint on information that he learned from that news reporter. The amendment claims it's reckless for him to base his complaint on what he'd heard from others. Now, Commissioner Hagan raised this exact same argument, including the same language, in his initial fees petition, which you've already dismissed as insufficient. And I would remind you, again, there's no requirement in the ethics rules or the statutes requiring that a complaint be based on personal knowledge. You often accept complaints based on news reports or based on secondhand knowledge. In fact, our rules provide that an ethics complaint can be based on hearsay. To facially plead the elements of the fees and costs statute, this petition would have had to substantively allege Mr. Neiman knew that news report was false or had reason to question it, but brought his complaint anyway. And no such specific allegation is made in the amended petition. And the petition next argues that there are 3 other ethics complaints containing similar allegations that were filed against Commissioner Hagan at the same time as Mr. Neiman's. The petition argues this shows Mr. Neiman and those other complainants were conspiring together to bring their complaints. But whether other complaints were filed based on similar allegations is not really relevant to, in my opinion, to whether Mr. Neiman knew or should have known the allegations were false when he brought his complaint. Just shows that other private citizens shared some similar concerns about Commissioner Hagan. I will say, too, it's curious that while Commissioner Hagan strongly emphasizes in his fees petition that the other complainants brought allegations almost exactly the same as Mr. Neiman's, he hasn't moved for fees against any of those other complainants, only against Mr. Neiman. The amended petition next claims Mr. Neiman should have more carefully researched certain allegations that were found to be false during the ethics investigation. Claims he should have made public records requests for meeting minutes from the county commission and records from the Division of Elections before filing his complaint. But the amended petition does not allege Mr. Neiman knew those allegations were false, only that he should have verified them before bringing the complaint. Commissioners, there's no requirement in the ethics statutes or the rules that a party must exhaustively research their claims before filing an ethics complaint. We don't want to stifle complainants by having them conduct an independent investigation on their own. That, to a certain degree, would supplant the investigative role of this commission, which, according to the Florida Constitution, is to look into and investigate possible ethics violations to determine their truth. Now, here again, it appears Mr. Neiman based his complaint upon information and statements concerning possible ethics violations that he had learned from an investigative journalist who was already researching those claims, a local TV reporter. He then filed an ethics complaint asking the commission to look into the allegations for their truth. And frankly, that's exactly what the commission has been asked and designed to do, especially when the allegations are coming from a credible news source. And there are two other arguments in the amended petition. First, that Mr. Neiman should have waited for the results of a criminal investigation into the commissioner's conduct before filing the complaint. That implies he was reckless in bringing the complaint before the criminal investigation ended. Apparently it's being conducted by the Hillsborough County Sheriff's Department, the State Attorney's Office, and the Florida Department of Law Enforcement. But that other investigation would have been into criminal statutes, not violations of the ethics code. Plus, the fact that numerous law enforcement agencies found these same allegations credible enough to launch a major investigation works against the claim that this complaint was recklessly filed. And finally, the amended petition lists 4 instances between 2009 and 2014 where Mr. Neiman criticized Commissioner Hagan's performance as a county commissioner in various emails and in newspaper articles. But it's unclear how those criticisms are relevant to any of the allegations in this complaint, and therefore I don't believe they're relevant to show Mr. Neiman knew or should have known the allegations in his complaint were false. So for those reasons, I don't believe this amended petition corrects the deficiencies in the initial petition. In my opinion, it doesn't raise any substantive, credible allegations explaining whether Mr. Neiman knew his complaint contained false allegations or acted with a reckless disregard as to whether it did. So I'm recommending that this amended petition be dismissed.
Thank you, Mr. Schaefer. Mr. Levine, you've got 15 minutes.
I won't take that long, Madam Chair. Madam Chairman, member of the Commission, Madam Executive Director, Mark Levine and Stivers here in Tallahassee on behalf of Commissioner Hagan. First, thank you for moving me up. I'm supposed to be at a 3 o'clock meeting in Atlanta, so I got to move a little here.
I wonder you're not going to take your 15 minutes.
I'm not going to take my 15 minutes. I would point out to you that all of the allegations made against Commissioner Hagan were not found sufficient. There was no evidence to support any of those allegations. We believe, and we believe we have pled properly, that Mr. Neiman filed with reckless disregard, did not check his facts, which he could have done. He did not examine public records, which indicated to the contrary, and he could have done. He takes the tip of a reporter, which now we understand to be the case, other than it being a news story, and it did not come from a news story. And I will tell you that the reporter in question is not a creditable source in this particular case. And we believe he was clearly on a mission to get Commissioner Hagan. I can tell you, pled a lot of pleadings in courts, things of that nature. I've never had such a difficult time in pleading as I have with this particular complaint. There's no question that I have pled the elements. The elements are there. Generally, when you plead the elements of an offense, it is then your obligation then is to move forward to prove those elements, and that is our burden to go forward to prove the elements. It is not, in my opinion, the position of this commission to take a look at this point about whether I can prove those elements. I cannot come to you unless I lie to you in an amended petition or an original petition and make statements of which I believe I know now without substantial proof. So what I've said to you in this amended petition is what I've pulled off of public records and social media, and clearly the basis of the complainant's knowledge, his feelings, his intent are not present on the face of his complaint. He did not make adverse statements against his interest to the investigator with the Commission on Ethics. The pleadings cannot get into his head. I cannot determine what Mr. Neiman was thinking and what he did and whether he did it recklessly without being able to take his deposition. There's no pre-discovery issues in front of this commission nor generally in any circuit court case. I'm sorry? Oh, okay.
Good.
So we know from what I have done in the amended complaint that Mr. Neiman calls Commissioner Hagan a crony. He pulls his family in the matter and then calls him a liar. Now, those things you may have a right to do with your public officials. I think we still have a First Amendment in this country. But those types of things that evidence his attitude and his feelings towards Commissioner Hagan are the types of things that I should be able to get into when I set Mr. Neiman for a deposition under oath. Those are the types of things about why he did this, how he did this, what he reviewed. The criminal investigation was not the result of a news story. It was a result of some political activity in the Hillsborough County area that caused not only Commissioner Hagan, but several other commissioners to be scrutinized in regards to how they do business on their cell phones. That's what it all stemmed from, because I represented a couple of them. And that's how it came about. All of this was investigated. Mr. Neiman could have read that report. It's several hundred pages long. I've got a copy in my office. It was available to him. And he would have known then at that time that those allegations that he made or was going to make are absolutely false and without any basis in law or fact. Did he do that? No. That, to me, is reckless disregard. He did not take it upon himself. The issue of whether my complaint rises to the level of an award of fees, I do not believe at this juncture is within the province of this commission. I believe that it is within the province of an independent administrative law judge. I don't prove my case, administrative law judge is going to give you a recommended order that says Levine didn't prove his case. You'll adopt that. If I prove my case, then I guess we can debate whether you adopt the recommended order or not. But to prohibit someone like Commissioner Hagan or any other public official from moving forward in a positive fashion to determine what the intent was. If we required in a complaint for an individual to state their intent, maybe I could plead it better. That's not required. It's never going to be required. It's not reasonable to make them required. They state their allegation. It's determined by your director as to whether it's legally sufficient, and if so, you move it to an investigation. That's proper, and that's what you should do. That does not thwart the public from making their complaints about public officials and others under the auspices of 112. To stop this proceeding at this procedural point, I believe is an affront to the good men and women who are subject to recognition under 112. You do not give them an opportunity to pursue avenues that are clearly available by law to them. They have a right to seek their justice, as Mr. Neiman had a right to seek his, for being wrongfully and negligently accused of public corruption. Neiman did not even consider the findings in the criminal investigation. And I can tell you the criminal investigation was extensive. It was obviously politically motivated, as most are. Okay? That's the way our society is. That's what happens. Look at what's going on several blocks away downtown with investigations and things. It is what it is. I don't propose to you to change that. What I propose to you is that people who are wrongfully brought into that and are exonerated from alleged bad behavior, to give them the right to come back and do what is right and just for them. I respectfully request that you allow the petition to move forward so that I can go to an administrative law judge and do the discovery that's necessary to make my case. Be happy to answer any questions.
Thank you, Mr. Levine. Are there any questions for Mr. Levine or Mr. Schaefer? Mr. Cox?
Yes, sir, Mr. Cox.
So I'm curious, you mentioned about the news reporter not being credible, and that was part of the problem for Mr. Hagan. Are you taking legal action against the reporter?
That has been considered, but I'm not at liberty to, it would not be what I would do personally, because that's not the kind of law I practice. There are issues in respect to this particular reporter that have been ongoing for months and maybe a couple of years. So there has been discussion about that type of thing, but I can't tell you at this point that there was any positive affirmative action moving forward. It's not the first time that we've been in this situation with this particular reporter.
Are there questions for Mr. Levine? Mr. Levine, if you'll just pause 1 second, I have a question for Mr. Schaefer, and if you'd like to respond to it as well,
I will.
you may. Mr. Schaefer, this calls into question to me the burden of the complainant to evaluate the credibility of the news source. I mean, what is our expectation, and how are we going to determine whether the complainant did what he was supposed to do going forward in order to make a determination of credibility?
Well, that's a good question. I think that, as I said before, I think the question here about whether or not the reporter was credible is not the key question that you need to be looking at. You have to be looking at whether or not the complainant knew that the report was not credible, the information was not credible at the time he brought the complaint, or had reason to question it. That's the particular question that's before you all. Now, I think your question too touches on what the degree of specificity should be in the fees petition itself. And I remind you, the rule says that the elements of the statute have to be pled with particularity at this stage of the proceeding, at the sufficiency stage. Now, at the last meeting, Commissioner Norris asked me to take a look at the pleadings for civil fraud in Florida, which also deal with that requirement that the allegations be pled with particularity. And I did some homework on that. In the case of civil fraud, it means that when you're pleading, you have to identify the specific fraudulent representations and allege why they were false. You have to look at the circumstances around it then and put that all in your pleading document. I think in this particular case, I think to have a facially sufficient fees petition, the commissioner have had to have alleged that Mr. Neiman knew or had that the report was not credible or had reason to doubt it, but brought his complaint anyway. That is the requirement, in my opinion, to be able to plead with particularity the elements of the statute.
It's a bit of an unfair question with that disclaimer. If this was, using your comparison or Commissioner Norris's to a civil fraud count, if this petition was in front of a circuit civil judge, it would probably meet the standards that are required to get by a motion to dismiss. So if you could just encapsulate one more time why this commission is really operating from a different set of standards in evaluating the motion to dismiss than the circuit civil judge would be.
Well, again, I think that the rule states it has to be pled with particularity. And I don't want to be beating a dead horse here, but I would direct you back to the fact that all we really have here is a petition that alleges that you had a news report that was not credible and that he based his complaint on that news report. That does not show that he knew or had reason to doubt the content in the news report, which is what we would need to find this complaint or petition sufficient, in my opinion.
Mr. Levine, you don't have to respond, but you're invited to.
Let me just say this. I believe that I pled it facially. Again, I've been doing it a long time. I've never had as much difficulty. I've said more than just it was based on a news tip from a reporter. I've said more than that. I've said that he did not do his due diligence. He made allegations that just by looking at the public record or asking the county administrator, I mean, the allegation that Commissioner Hagan engaged in behavior that was inappropriate under 112 by voting for Parsons Brinkerhoff's contract when in fact Commissioner Hagan never had the opportunity to vote on that contract. Mr. Neiman goes to these commission meetings. That was a decision made by a county administrator without a vote of the county. That allegation was prominent in this complaint. Mr. Neiman knows better, and it's damaged Commissioner Hagan. It's been in the newspaper, and the reporter continues to pound on it. And I believe that I have sufficiently pled it to get by a motion to dismiss so that I can go forward and try to prove my case. It's only when I get into his head and the others involved that I can be able to show the absolute elements beyond proof by a preponderance of the evidence that these things occurred. I should have that opportunity. Thank you, Madam Chair.
Thank you. Any other questions for Mr. Levine?
As being the personal knowledge of the complainant, right? And so if the matters that are not your personal knowledge is what is the basis of your complaint, do you not see that there is some duty to question whether or not you know that that's true?
From what I'm understanding, you're asking me then, whenever we have a complaint that's not based on personal or direct knowledge, we're going to be holding the complainant to a higher standard than we would to any other complainant. And
I would, in fact, not to argue with you, but in fact, I think we don't. That's my point, all right? We evaluate the complaint based upon the allegations of the complaint as to whether or not it's sufficient. Why is the standard different now in the public official who's been accused rendering his complaint authorized by statute to seek the redress of attorney's fees?
Well, in response to that, I do think that there's a difference in the pleading requirements for attorney's fees petitions and ethics complaints. And if you would just give me a second here, I can quote that for you. Okay, I'm looking at Rule 34-5.002 subsection 1, which sets out the requirements for a legally sufficient ethics complaint. And it says here, complaints need not be as precise as will be required by the rules of civil procedure in a court of law, and shall be deemed sufficient if the complainant under oath, upon knowledge or belief, alleges matters which, if true, may constitute a breach of public trust. And it goes on to state, a complaint shall not be insufficient because it is based upon evidence which would be hearsay evidence in a court of law. Now, if you would contrast that with Rule 34-5.0291, subsection 2, which talks about petitions for attorney's fees, it says such petition shall state with particularity, which I think I've already described as a higher burden, the facts and grounds which would prove entitlement to costs and attorney's fees. So I think in our rules there is a distinction between the pleading requirements in an ethics complaint and the pleading requirements in an ethics petition, in a fees petition.
I don't disagree with that point. But what I disagree with is the standard that you're applying to at the pleading stage for the petition for attorney's fees. I mean, we have approved petitions. Every case is going to have its own facts and its own different nuances, but we've approved petitions for attorney's fees that are facially the same as the petition for the attorney's fees in this case.
I would disagree with that. I think in the other cases, since I've been on the commission, where you've approved an attorney's fees petition and found it sufficient to send to DOA, there have been outside circumstances that showed that the particular complainant knew the allegations in the complaint were false, or at least had significant reason to doubt them, because they were citing a newspaper article perhaps that did not support what they were alleging in their complaint. That would be one example that springs to mind. In this particular case... Is that what Mr. Levine, I mean, in so many words, is that what Mr. Levine's client is? Well, what I mean is the newspaper article... It's a TV report? The newspaper article said 180 degrees the opposite of what was alleged in the complaint. That's what I mean. In this particular case, you have a very, whether or not the news reporter was credible or not, it was a very widely reported story that he was basing his complaint on. And again, this story was credible enough to spark a major law enforcement investigation from 3 different agencies in the Tampa area. The complainant here saw the story apparently and filed this complaint. In my opinion, that is what he should have done in these circumstances.
So at this point, let me just intervene. It's typical for those of us who are lawyers on the commission to want to engage in a legal debate, but both with staff. So we just have to remember that Mr. Schaefer's position here is just to offer an opinion, not to be an advocate for a particular position. So just keep that in mind as he's responding to questions. I'll come back to you, Commissioner Norris. Let me get Mr. Levine.
One comment. I think Mr. Schaefer does a great job. He's got a great teacher over here who's been my friend for a long, long time. I don't know how he knows these facts that I don't know. That I've been standing here dealing with this case now, what, for a year and a half? And he's sitting here and stating facts about a newspaper article triggering a major criminal investigation. That is not what occurred here. There was a major criminal investigation. That's not what brought Mr. Neiman to bring this complaint. So I don't know how Mr. Schaefer knows these things that I don't know. I think I've read everything he has to read. I've got an investigative report. I've dealt with Keith on several occasions about it, and I still don't know these things. But if those things are what he says are true, maybe I should plead those. Maybe I should interlineate the pleadings right now. I think I have a right to move forward to prove my case. If I can't prove my case, I can't prove my case. Sometimes we win, sometimes we lose as lawyers.
Thank you, Mr. Levine. I'm going to give Mr. Schaefer one opportunity to wrap up, and then we're going to move into a discussion of the motion among the commission.
Am I dismissed?
Just hold on one second.
My only response to Mr. Levine, in all due respect, is I'm pulling that from his amended petition. I'm looking at page 5, and where he says that there was an exhaustive investigation done by the Hillsborough County Sheriff's Department and the state attorney, along with the Florida Department of Law Enforcement. So I don't know the specifics of that investigation, but that is where I pull that information from the amended petition itself.
Thank you both, gentlemen. I know we could both probably hear more from you all day, but I think we have a pretty good flavor of both the legal and the factual questions. Thank you for your time. And at this time, I'd ask if there's a motion from the commission.
Madam Chair.
Mr. Cox.
I will move that we approve the order dismissing the amended petition for attorney's fees and costs.
Is there a second?
I'll second that.
It's been moved by Commissioner Cox and seconded by Commissioner Brady to approve the recommended order dismissing the petition for fees. Is there a discussion?
You know, I will say, under discussion, having been a county commissioner, just because something didn't come before the commission for a vote does not mean that the commissioner doesn't have the ability to talk to the county administrator, other senior staff, to project their feelings and their desires of certain things to get done. The fact that it just didn't have a vote before the commission is immaterial. That doesn't mean that you don't use your position to try to push a belief or something that you want to get done forward. So that argument does not ring with me at all. And there's a high bar for this for a reason. And what we don't want to have happen is for people around this state to say, yes, I'm not going to file a complaint because the elected official will use his or her position and the taxpayers' dollars to go after me as a complainant. And that's what's happening here. You know, the other elected officials that were accused of some of these similar allegations that were dismissed, they are not moving forward with this, but Commissioner Hagan is, and he's using the taxpayers' dollars to do it. That's unfair. So I think this is a very clear situation that we need to approve this and move on.
Commissioner Berger.
I just think in looking at it, there are many cases where the advocates recommend no probable cause. There's many cases where we vote no probable cause. And that's why I think we're in the situation on this case where there has to be a good analysis of the case. Not every case out there is going to be an attorney's fees case. And we have to digest the pleadings and the facts to come to this, because otherwise, I agree about there's reasons why the statutes are posed differently. One is on the fining level, 2 is on the fees level. And in this instance, in this case, based upon the facts presented, I agree with the recommendation.
Thank you, Commissioner Berger. Commissioner Norris.
I would simply point out, I don't disagree with anything that my fellow commissioners have just said. I agree completely. Public officials are taxpayers too. We have an equal duty as this commission to the folks who make the complaints as we do to the folks who respond to them. duty is the same. The analysis, under the rule, the code of ethics needs to, apply. So, we are not the trier of fact. This is simply a base sufficiency level decision as to whether or not that case can move forward. Whether or not the particular public official in a particular case chooses to go after multiple, the multiple complainants or just one or whatever, there's all kinds of different factors that may be, that may fall into that. Maybe an analysis of counsel as to, well, this one was malicious, but those weren't. This one meets the standard, those don't. And ultimately, though, just like our executive director makes a facial finding as to whether or not this complaint is sufficient to get the review, that's what we're doing here. Is this sufficient to get the review? He can't prove his case otherwise. He can't get there otherwise. So I'm just looking for some balance on it. I don't know exactly where that is. And so I'm going to vote against the motion. I don't expect my vote to prevail.
Thank you, Commissioner Norris. Commissioner Brady.
I mean, when we look at this process, my sense is that when we have a finding of no probable cause, we in essence provide justice to the respondent, that we have an opportunity to look at what occurs, the investigators investigate the complaint, the advocates develop a recommendation, and we tend to adopt the recommendations that the advocates make. So the justice for the respondent is made when we say, we don't think this happened. There is no reason to believe that this is a violation of the ethics laws. And to really permit people to say, well, gee whiz, I want revenge because this guy embarrassed me, because this guy made me look bad in the eyes of the community, without really an extremely clear, obvious evidence is not the right word, proof that it was done maliciously to really damage someone's reputation. I think we need to set a very high bar in terms of allowing respondents to go back after complaints simply to maintain the fairness of the process. If you think that you can get sued because you made what you think is a legitimate ethics complaint, you're not going to make complaints. And I think we need to be very careful in terms of granting fee requests or granting people to proceed with fee requests unless it is very evident that it was done maliciously with real intent to harm reputations.
Chairman?
Commissioner Norris.
If the legislature determined that justice for the public official was simply a finding of no probable cause, then they wouldn't have the attorney fee provision in the statute. It's there, and it is there for a reason. So that in and of itself is not necessarily justice, and justice, of course, is always going to be in the eye of the beholder, right? So the issue is, has this public official presented a complaint before this commission seeking attorney's fees that pleads the statute elements with specificity? That's the higher standard. And either the commission either says, yes, they have, and if so, then that person is entitled to their quote-unquote day in court as a public official, just like the complainant was entitled to the day in court to bring the complaint in the first place. Or if the commission's answer is no, this doesn't meet the standard, then so be it. That's the vote of the commission. I just think there needs to be a balance, and if you plead, because otherwise, it seems to me we're creating our own standard that I'm not sure how it gets met. Because I keep hearing my fellow commissioners who I have great respect for talking about proof, talking about evidence, not talking about the pleading.
Thank you, Commissioner Norris. Commissioner Cox?
Thank you, Madam Chair. You know, the majority of these complaints, the vast majority of these complaints are brought to us by lay people who believe that a public official may have done something wrong. And the statute is written specifically to cause this next phase for attorneys' fees and costs to rise to the level that they did it maliciously, that they knew that this was an absolute falsehood, that what the complaint that they were doing was malicious and it was full of lies. If you put yourself, for a minute, assume that you are not an attorney that understands the law, that you are just a layperson who sees a news report about an elected official, and that law enforcement finds it potentially grievous enough to do an investigation, to spend resources and energy to do an investigation, not just one law enforcement agency, but I believe 3, to find and in the case that let's go and look at this. They have a different set of standards, so they determine it's not criminal, but is it ethical or not? I think a layperson who files these complaints looks at that and says, you know what, I think it's my public duty to ask that question. Now, if this commission allows those lay people to be put at a disadvantage, then we're creating a big can of worms that should never be opened. You know, as you know, I feel like the complainants should be heard during these hearings, but we take that right away from them as well. So they're at a disadvantage from the second that they sign their name to a complaint. And if you let this go forward, you're doing an injustice. So I'll shut up.
Commissioner Berger.
I just wanted to say that I agree with Commissioner Norris's analysis on the issue involved. But we had 2 different sets of arguments about the pleadings from each side. So I agree with his analysis on the law and what the law is and what we're looking at, but we do need to look at both sides of the argument, and some commissioners may be swayed by one, some may be swayed by the other. I mean, the law is the law, and that's what we're supposed to follow. But at the end of the day, you know, not speaking on any other cases, but this one here, we've heard 2 compelling arguments, both done very well by both sides. And that's really what it comes down to.
Thank you. Anyone else? I'm going to just comment that I am sympathetic to the attorney who represents a public official that is trying to meet this standard and not be able to do the investigation. I am flummoxed, and had we not dismissed or granted other petitions for fees, I would probably think this just couldn't ever be met. But I know we have met it in other circumstances, and that's really what in the end will affect my vote today. Otherwise, you know, I think I agree with and see it the same way as Commissioner Norris. Any other discussion? All those in favor of the motion that recommends adoption of the order dismissing the petition, please indicate by saying aye.
Aye.
Any opposed?
Nay.
The motion passes. Thank you. Thank you, Mr. Levine, Mr. Schaefer, and commissioners for an important discussion about that difficult issue. At this time, we'll move to item 4 on your agenda. This is consideration of final action on pre-probable cause stipulations. We'll take up item 16-123. in re Andrea Young. Will the parties or their counsel please identify themselves for the record?
Melody Hadley, Commission Advocate.
Is there anyone here on behalf of the respondent? No. Thank you. Just to refresh everyone on what we are doing here, after considering all the materials and presentations by Ms. Hadley, the commission may vote to approve or reject the stipulation. As this is a pre-probable cause stipulation, if the stipulation is rejected, we go immediately into the probable cause determination. Ms. Hadley, will you present the stipulation?
At this time, I bring before you a pre-probable cause stipulation. Respondent acknowledged that she failed to accurately file a 2015 CE Form 6 in violation of Article 2, Section 8 Florida Constitution and Section 112.3144. Subsequent to the filing of the ethics complaint, respondent filed amendments for the year 2015. We asked the commission to accept the respondent's stipulation and recommend a total civil penalty of $500.
Are there any questions for the advocate?
Move for approval.
Second.
Commissioner Brady, did you have a question or was that a motion?
Is this in addition to the penalties for not having filed, or this is total penalties?
This is a different issue. This isn't, I'm not positive if there's an issue with her filing or not. This isn't a willful issue. Excuse me, this isn't a willful case. This is just about the content of her form and that there were mistakes in the form.
Filed talent, okay, that's fine.
Thank you. Following that question, I believe I heard a motion and a second. Any other discussion? All those in favor of the adoption of the proposed stipulation, please indicate by saying aye.
Aye.
Any opposed? The stipulation is adopted. The next item is 16-168.
Madam Chairman,
Yes.
I just want to disclose for the record that the public official in this particular case is from Columbia County. It's not the biggest, it is the center of the universe, but it is not the biggest county in the state. And so this is a gentleman that I, know, have a personal acquaintance with and friendship, but not any kind of business relationship. I don't work for the county or anything like that, so I don't think it's anything that creates a voting conflict at all, but certainly is someone that I know.
Thank you for that disclosure, but no conflict there. Any other comments before I ask the advocate to present on the matter involving Russell DePrater? Thank you. You may begin.
Thank you. I'm Elizabeth Miller, advocate for the commission. In this matter, we have a joint stipulated pre-probable cause agreement. The respondent is a member of the Columbia County Commission, and I understand that I may have referred to it as Lake County at some location, and I would like to orally amend that. It is Columbia County. There are 8 allegations. I recommend probable cause on 2 of the 8 allegations. That would be allegation 7 and allegation 8. Allegation 7 is a conflicting employment or contractual relationship. Allegation 8 is a voting conflict. The respondent admits the allegations or the facts that make up allegations 7 and 8. He denies the facts that make up allegations 1 through 6. I have asked for $500 for each allegation for a total of $1,000, along with a public censure and reprimand. Mr. Dietzen represented that his client would pay the total of $1,000 immediately. I would like to point out that if we went to a post-probable cause stipulation, or if we prevailed at a final hearing at DOA, we would obviously ask for more money. I realize that this amount may not be satisfactory. However, I do respectfully ask that you ratify the joint stipulation. Thank you.
Thank you. Any questions for Ms. Miller?
Madam Chair. Ms. Miller referred to that it may not be satisfactory. I'm the one that's not satisfied with that. I look at the prior case that we just had. That was a case where an individual listed that they had an IRA but did not list all the assets inside that IRA. That is a mistake that is made every year at filing time by probably hundreds of people. We find that individual $500 for that. And I think that was an appropriate amount. Quite sure they'll never do it again, and it sends a message to other people. This case, these allegations are much more egregious in my mind. It's where they're using their position for special private gain or loss, and $500 in my mind is not enough when the county commissioner is saying, yes, I did it. They're admitting to that in this, but I just don't think it's enough money.
I understand, sir.
Thank you. Any other comments or questions from the commission for Ms. Miller?
I guess if I may,
Commissioner Berger?
I guess the question would be, how did you come to that number on this case?
We negotiated. It was not what I originally wanted, but that was the amount we negotiated.
Can I ask what you originally wanted?
$1,500 per allegation.
I would support that.
Would you like to support that in the form of a motion, or would
So-
anyone
so-
else like to? Yes. Well,
Commissioner
I realize that he can't.
All you can do is
Stipulate
vote it
that.
up or down.
Yes, I knew that. I was
I'm
just being sarcastic, that I knew that was coming from him, so I'm just.
I was about ready to make a motion.
I'm prepared for him. Anybody else want to make a motion before Commissioner Cox? Go ahead.
I will move that we deny the pre-probable cause joint stipulation.
Is there a second? Hearing none, the motion fails. Is there another motion? Is there a second to the motion to adopt the pre-probable cause stipulation?
Second.
It's been moved and seconded. Is there any discussion? All those in, Commissioner Brady?
Okay. Yeah, I mean, when I read the report of investigation, I was kind of surprised that this had gone to a whatever we call this before, because it did appear that these struck me as somewhat sinister, that I bought land and I knew the land was gonna go someplace, and I sold the land, and I'm on the commission, and I, knew there was a fence company, but I really didn't know, and I asked somebody, and I don't know anymore. I mean, it struck me as not something you would like to get off with $1,000.
Do you want to respond? You do not have to. Actually, it's not even appropriate.
I know,
We have
I
a
know.
motion and a second on the floor. Any other discussion? All those in favor of the motion to adopt the pre-probable cause stipulation, please indicate by saying aye. Any opposed?
All right.
The motion passes.
Thank you very much. I will take your concerns to heart.
The next pre-probable cause stipulation is matter 17-003 in Ray Smith. I believe there's anybody here on behalf of the respondent. Correct? Oh, Mr. Thank you. Ms. Hadley, you may begin.
At this time, we bring before you a pre-probable cause stipulation. Respondent acknowledged that he failed to accurately file a 2014 and 2015 CE Form 6 in violation of Article 2, Section 8 Florida Constitution, and Section 112.3144. Subsequent to the filing of the ethics complaint, respondent filed amendments for 2014 and 2015. We ask the commission to accept the respondent's stipulation and recommend a total civil penalty of $1,750.
Thank you. Mr. Herron, do you have any?
Mark Herron on behalf of Kurt Smith. This proposed penalty is consistent with the other penalties you've done on Form 6 financial disclosures recently, and we would suggest or urge you to adopt the joint stipulation.
Thank you, Mr. Herron. Any questions for Mr. Herron or Ms. Hadley?
Move to adopt.
It's been moved to adopt the proposed pre-probable cause stipulation. Is there a second?
Second.
Any discussion? All those in favor, please indicate by saying aye. Any opposed? Motion passes and the stipulation is adopted. Thank you, Mr. Herron. The next matter is item 17-089 in Ray Reeves. And just to note in your materials that there is a submission from the complainant. The complainants have a right to comment in writing on the proposed stipulation, and that's included in your files. Is there anyone else here? I don't believe so, on behalf of the complainant or respondent. Thank you. Would Mitch Reeves identify? Thank you. Thank you very much. Ms. Hadley.
At this time, we bring before you a pre-probable cause stipulation. Respondent acknowledged that he violated section 112.3137 by having conflict employment with GT Distributors while it was doing business with his agency, the City of Atlantic Beach. There is insufficient evidence to show respondent violated sections 112.3133 by doing business with his agency, or section 112.3143 by voting on a matter in which he received a special private gain or loss. We ask the commission to accept respondent's stipulation that he violated the ethics code and recommend a total civil penalty of $1,000 regarding allegation 2 and dismiss allegations 1 and 3.
Thank you. Any questions for Ms. Hadley? Ms. Bloom?
Good morning, and I'll be brief. I would just request that you guys accept the stipulated consent agreement, and I'm here to answer any questions if you have them.
Thank you. Any questions? Appreciate your being here. Thank you for being here, Mr. Reeves. Is there a motion?
Motion.
Commissioner Berger, I believe, moved to approve the proposed pre-probable cause stipulation. Is there a second? It's been moved and seconded. Any discussion? All those in favor of the motion, please indicate by saying aye. Aye. Any opposed? The motion passes and the stipulation is adopted. Thank you for being here. Comments? The next matter is item 5, matter 16-023 and 16-031 that have been consolidated. This is the attorney's fee petition filed by John Drew seeking fees against complainant Carlos Slay. It was found legally sufficient and sent to the Division of Administrative Hearings. Mr. Drew and Mr. Slay have reached a settlement, and DOA has relinquished the case to our jurisdiction for dismissal. Are either Mr. Drew, Mr. Slay, or their counsel present? Yes, would you please introduce yourself for the record?
Leonard Collins, on behalf of Carlos Slay.
Thank you. Thank you for being here. Do you have anything that you would like to say other than you have this settlement that we have in our materials?
Yeah, well, on behalf of Mr. Slay, actually, I'm very heartened at the discussion that occurred earlier today on a similar type of matter. And we would encourage this commission perhaps to consider a two-way attorney's fee in the future, so that if a complainant is put in the position of having to face someone who's an elected official who's using public funds to prosecute a case against them, if they're successful, they should have an opportunity to recover their attorney's fees, because these attorney's fees in a case like this are very significant.
Thank you.
Sure.
Any questions? Ms. Goss?
Just as a comment, a reciprocal attorney's fees provision has been in the commission's legislative recommendations for at least the last 2 years. So that is something the commission is very interested in, but it takes action by people other than us.
And if you stay long enough, we'll probably have a brief discussion about those people a little bit later. Thank you. Any other comments, or do I hear a motion on the fee petition or the recommended order? It's been moved and seconded to adopt the recommended order. Is there any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Motion passes, the order is adopted.
So moved.
Thank you. Skipping down to item 7, consideration of probable cause. This is the the probable cause hearing of complaint number 16-148. N. Ray Marnie Retzer, currently Sawicki. It's being heard in our public session because the respondent has waived confidentiality. Is either the respondent or the complainant or their counsel in attendance? Mr. Heron.
Mark Aaron on behalf of Marnie Sawicki.
Thank you, Mr. Heron. Just for the benefit of the commission, the probable cause determination, as you know, is the conclusion of the preliminary investigation. The respondent and the advocate are permitted to make brief statements in the nature of oral argument to the commission based on the investigator's report, the advocate's recommendation, the complaint and staff recommendations, as well as any other written statements submitted by the respondent. But it's important to remember that no other testimony or evidence can be accepted. Ms. Miller, you have
Thank you. Good morning again. Elizabeth Miller, advocate for the commission. Respondent served as the mayor of Cape Coral. She also had a personal relationship with a man by the name of Brian Rist, who owned a company that was a vendor of the city of Cape Coral. The allegations all pertain to her either soliciting or accepting or not reporting gifts that she received from Brian Rist while they were in a personal relationship. The gifts were all jewelry. As far as the other allegations, the condo or renting the condominium and the vehicle were not gifts. The gifts of jewelry were all valued at over $100, and they should have normally been reported on the gift form. However, in this situation, there is an exemption, and that is because the respondent and Mr. Rist were in a relationship, and the respondent, through her attorney, said that she intended to form a household with him, and at some point she did live with him. It appears that the law pertains only to her subjective intent, that they intend to live together in the future, and not based on any other circumstances. For that reason, she did not report or need to report the gifts. As far as the solicitation or acceptance of gifts allegations, there was no evidence that she did either. The evidence is that she accepted these gifts based on the personal relationship. Therefore, for the 4 allegations, I recommend no probable cause. Thank you.
Thank you, Ms. Miller. Any questions for Ms. Miller? Hearing none, Mr. Heron.
Thank you.
Mark Heron on behalf of Marnie Sawicki. Ms. Sawicki would respectfully request that this commission adopt the advocate's recommendation. As you see from the report of investigation, they were involved in a romantic relationship. And again, speaking of those folks down the street who defined relative, they have defined relative to include these types of relationships, and as a consequence, gifts that are given in the context of this relationship are not reportable. The report of investigation also showed that no action was taken by Ms. Sawicki in her capacity as mayor that benefited Mr. Rist's company or his economic interests. In fact, no matters came before the commission while she was in this relationship with Mr. Rist. There was an issue, if you recall, perhaps with respect to him providing money to the city for the 4th of July celebrations, which he did. But again, that was not the type of contractual relationship that is covered by the statutes. And again, we'd ask that you adopt the advocate's recommendation, find no probable cause, and dismiss the complaint.
Thank you. Any questions of Mr. Heron? Thank you, Mr. Heron. Would entertain a motion on this probable cause matter.
Move for approval of advocate's recommendation.
Is there a second?
I'll second that.
It's been moved and seconded to approve the advocate's recommendation. Is there any discussion?
Clarification, advocate's amended recommendation.
Amended recommendation. Thank you. That's accurate.
Yeah.
Any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? The motion passes and the amended recommendation is adopted. Yes, Commissioner Brady.
For the conclusion that there's a relationship between the parties is simply based on their statement?
Is that, who would you like to direct that to?
They say, we're in
Ms.
a
Miller?
romantic relationship, and he gave me a ring, and the recipient of the ring says, oh, yeah, we're in a romantic relationship, and the giver of the ring says, oh, we're in a romantic relationship, and we say, oh, okay, that's fine. I mean, is there any criteria beyond statements of the co-conspirators that indeed is true?
Even though we've taken a vote on this matter, as a courtesy, I'd ask first, Ms. Miller, if you'd like to respond, and second, Mr. Hare.
Those were just.
I mean, it was really.
It was not, yeah.
You don't really think that's
It's clear they lived together. I assume that they had a relationship. But I mean, I just wondered myself, is it simply an assertion that, yeah, we were dating and that's why I gave her the ring and, and it didn't work out.
Ms. Miller, you're off the hook because Ms. Doss volunteered to speak to the process of the investigation and how that's determined. Thank you, Ms. Doss.
Indeed, that question really kind of goes to the process of our investigation, which is where the investigator asks the parties involved. I doubt that in this situation he went around and, polled the neighbors to see if they really did seem happy together. But the law does provide that people who make it known that they intend to make a household together are considered relatives. And if the investigators don't see any reason to doubt the testimony of the people involved, then they typically don't go any farther. If they do see reason to doubt it, then they go further.
Thank you. You're off the hook too, Mr. Heron. Thank you. We'll proceed to matter 17-145 in Ray Doug Underhill. Is there any person present on behalf of the complainant or the respondent? Yes, sir. If you'd introduce yourself for the record, please.
Yes, ma'am. Thank you very much, Mr. Chairman. I am Doug Underhill. I'm the respondent.
Thank you. Anyone else? Thank you. Ms. Hadley, would you make your presentation?
Thank you. Respondent is alleged to have violated Section 112.3136 by requesting that Escambia County Commission approve the payment of his legal expenses from lawsuits pertaining to alleged actions taken in his private capacity. In November 2014, Respondent was elected to the Escambia County Commission after defeating Gene Valentino, who had previously served in that position, and he's defeated him during the 2014 Republican primary. On August 12, 2015, Valentino filed a lawsuit against Respondent for defamation. The lawsuit was dismissed with prejudice on November 19, 2015. On July 7, 2017, Valentino filed a second lawsuit against the Respondent and included Ray Guillory, a candidate in the 2014 Democratic primary, as a defendant. This lawsuit alleges that Respondent and Guillory exchanged text messages in which Respondent defamed Valentino with messages subsequently posted on Facebook. Respondent brought Valentino's second lawsuit to the attention of the county attorney. The county attorney advised that the respondent expressed concern about his ability to pay his legal expenses in defending himself against Valentino's lawsuits. They discussed ways he could deal with the legal expenses. One option discussed was whether Respondent could establish a legal defense fund. Another option was whether the county commission could approve the use of county resources for Respondent's legal defense. As a result of the discussion, the county attorney suggested that they take the issue before the county commission. The county attorney advised that Respondent did not direct this action and that there was no pressure from him to place the matter on the agenda for a county commission meeting. The county policy regarding legal representation states, in part, cases involving current and former county commissioners personally named in any civil, criminal, ethics, administrative, or professional licensing case that arise out of in connection with their scope of county function should be addressed by the Board of County Commissioners on a case-by-case basis. At its September 27, 2017 meeting, the County Commission discussed paying for Respondent's legal expenses associated with the first lawsuit and voted that it was not appropriate. Regarding the second lawsuit, the County Commission voted to seek an opinion from the Florida Attorney General as to whether it was appropriate for the county to pay Respondent's legal expenses. The Attorney General issued an opinion recommending that the County Commission not approve the use of county resources towards respondents' legal expenses. Respondent denied trying to influence the county attorney to take the matter before the County Commission. He maintains that he relied on the county attorney's reliance regarding the Commission's review of the issue of paying his legal expenses. While respondent was seeking a benefit, there is insufficient evidence to show that his actions were taken with a corrupt intent, as he sought the counsel of the county attorney prior to making a request for the payment of his legal expenses. I recommend the finding of no probable cause.
Thank you, Ms. Hadley. Any questions for the applicant? Thank you. Mr. Underhill, you're invited but not obligated to make remarks.
Thank you very much, Madam Chairman, and I'm glad that I'm not sitting up there and having to make determinations about the definition of an intimate relationship. That will not be the case in here. I want to just simply bring up the what is very clearly defined in the findings that were put before you by the investigator, that at no time was there an effort to get taxpayers to pay for legal fees. The entire purpose for bringing all of this to the forefront was to take this practice of politics by litigation out of the shadows and put it in the sunlight. People are often reluctant to do that because of the level of shame that comes with actually standing here in front of an ethics commission and those kinds of things. But it's imperative that as we grow and evolve our society, that we do not create a society in which a vanquished political opponent can then use the mechanisms of government as a weapon against those who the citizens chose to replace him in office. You heard the testimony of 2 lawsuits, both of them now been thrown out. The claimant here is actually a recently retired county commissioner with 20 years of service under this ethics board, knowing full well what ethics is and what ethics is not. And as you can see in the claim itself, the actual claim that former Commissioner Wilson Robertson made is actually a question instead of the very definitive statements of fact that you would expect to see in an ethics complaint. So I would just draw your attention to a couple of very important sentences that were made in the investigation by your investigator. The complaint, therefore, is legally insufficient. The allegation is not sufficient, as there are no factual allegations. So I would ask that you find in keeping with the content of the investigation that was done. And I thank you for the opportunity to bring this forward, because excellence will always invite scrutiny. And so it is an opportunity. It's not, while it certainly feels uncomfortable to be standing here, it's always a great opportunity for an elected official to stand having been fully investigated and to be found to be doing business the right way. So thank you very much.
Thank you, Mr. Underhill. Any questions for the respondent? Thank you for being with us.
Thank you, ma'am.
Taking the journey. There are no other questions. I would entertain a motion regarding the proposed stipulation. It's been moved to approve the stipulation. Is there a second? Any discussion? All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The motion passes and the stipulation is approved. Excuse me? I mean, advocate's recommendation. Thank you. Thank you. Why don't we take a 10-minute break and we'll reconvene at 5 minutes till. Thank you. Commissioner Kuhn, I should say, last night, and was very moved and impressed by her commitment to public service, and particularly her interest in helping kids of DeSoto County. So I hope you bring those same talents and energies to this commission.
Thank you so much.
The first advisory opinion is file 2710, which will be presented by Mr. Gray Schaefer. Is the requestor here? Mr. Schaefer, would you present the opinion?
Thank you, Chair. Commissioners, this opinion involves a fairly straightforward application of the post-employment statute that applies to state employees, in particular former state SES and SMS employees. And what that statute says is that it prohibits them from returning to represent a paying client before their former agency for 2 years after they vacate public employment. And this request has been brought by a former senior attorney with the Department of Health, and he's just wondering to what extent that 2-year prohibition is going to apply to him, because I believe he left the department in December or January. On the surface here, the statute does apply to him because he is a former SES employee. So the question then becomes, what exactly is his agency? Because that 2-year prohibition will only prohibit him from representing paying clients before his former agency. And in the past, what you've done is you've chosen not to look at the gigantic State Department where one works, or one used to work, to figure out what their agency should be, but you've looked at the lowest departmental unit where their influence extends when figuring out what one's agency should be. In the past, what you've done is you've broken down a State Department to the bureau level when determining one's agency, and you've also just practically looked to see if their influence extends anywhere outside their bureau. Now here, this attorney worked in the Prosecution Services Unit, which appears to be the functional equivalent of a bureau there at DOH, and he presented cases before the Board of Medicine. So it appears here that the Prosecution Services Unit was the bureau where he worked, so that would be his agency. He presented cases before the Board of Medicine, so his influence extended there. And so the draft is just recommending you find his former agency will be the Prosecution Services Unit and the DOH Board of Medicine, and that he'll be prohibited for 2 years from taking clients before those 2 entities. And his only other question is that he wonders if he can represent private paying clients before other DOH boards besides the Board of Medicine. And he also wonders if he can represent private clients at DOA in litigation that's adverse to the Department of Health. And now on the surface, it doesn't look like his influence extended to any other DOH board, so I don't believe they should be considered his agency. And he wasn't employed at DOA, so I don't think DOA should be his agency either. So it doesn't appear on the surface here that he's prohibited in the next 2 years from bringing paying clients before other DOH boards or DOA, although I will say if his representation requires him to make communications with staff or attorneys at the Prosecution Services Unit or at the Board of Medicine within the next 2 years, then I think that could trigger the statute, because then we would have a prohibited representation with his former agency. So I submit the draft now for your review, and I'm happy to answer any of your questions.
Are there any questions for Mr. Schaefer? Commissioner Brady?
Yeah. So he can't go before the Board of Medicine, and he can't talk to anybody in the medical, nursing, or allied sections of the prosecution service, but can he go before the boards of nursing and allied sections if he doesn't communicate with, I mean, I wasn't.
His influence didn't extend to those other boards, so I don't believe they should be considered his agency. However, practically speaking, the Prosecution Services Unit handles prosecutions before those other boards, so if his representation is going to require him to communicate with the attorneys or staff at the Prosecution Services Unit, even if the matter is going before the Board of Nursing or any other DOH boards, then I think he will have a problem, because he'll be making a prohibited representation. But it'll just apply for 2 years after he leaves his position.
Okay, but I would assume it would be difficult to represent somebody before a board when you couldn't talk to the people that were basically bringing the action before the board.
Practically speaking, yes.
Okay.
Any other questions for Mr. Schaefer? But within the 2-year period, he can have communications with other members of the General Counsel's office, just not those that were affiliated with the Prosecution Services Unit?
Yes. I had to call over to the Department of Health to kind of figure out their governmental framework, and I talked to the Chief Legal Counsel in their HR department. She clarified that the Office of General Counsel at DOH has some general oversight over the Prosecution Services Unit, but the Prosecution Services Unit isn't housed in the Office of General Counsel. It's in the Medical Quality Assurance Division. So that's why the opinion doesn't recommend you find that the Office of General Counsel is his agency, because he doesn't appear to have had any direct communication with the General Counsel's office.
Just out of curiosity, I mean, if he had had communication or not, is it really the fact, is it really the fact that he hasn't had communication, or is it the fact that they really are not fused together, the prosecution services unit and general counsel?
It's
I would
both.
feel better if it was the more structural question rather than just measuring whether he happened to have talked to them or not.
It's both. Again, structurally speaking, it's not in the Office of General Counsel. Practically speaking to him, he claims that while his supervisor occasionally had communications with the General Counsel's office, he personally didn't. The opinion that I really looked at, and I have it cited in the draft before you, is I believe it's 17-2, and that dealt with an attorney at the Department of Revenue who was in a separate bureau from the Office of General Counsel, but he had regular communications with the Office of General Counsel. So you all found his influence extended to the General Counsel's office, even though his bureau wasn't technically housed there. Here, just from speaking to him, it didn't appear that he had lines of communication on a regular basis with the General Counsel's office. So that's the distinction in my mind.
So it is important to remember this applies to those factual circumstances, and his
Yes.
particular communication history would not necessarily be the same for everybody even in the same office.
Yes.
Any other questions for Mr. Schaefer? We do not have the requester here, so at this time, it would be appropriate to entertain a motion on the draft opinion.
Motion.
Commissioner Berger moves the approval of the proposed advisory opinion. Is there a second?
I'll second.
Any discussion? All those in favor of adoption of the proposed opinion, please indicate by saying aye.
Aye.
Any opposed? The motion passes and the proposed opinion is adopted. Moving now to file 2711. Please note that during the break, we were provided with a handout from the requestor, and it is in front of you, or near your computer, dated March 8th from Ms. Hodges. This proposed opinion will be presented by Mr. John Knight, and I believe the requester is here. If you please stand and introduce yourself for the record. Thank you for being with us. Mr. Knight, would you present the opinion, please?
Thank you, Madam Chair. As you have read in the draft opinion, the question presented here is whether there is a prohibited conflict of interest where a member of the City Council for the Consolidated Government of the City of Jacksonville owns a construction company providing services to the school board. There are two statutes that are applicable in this situation. The first one is the prohibition against doing business with one's agency, and the second one is the prohibition against conflicting in employment contractual relationships. There are two parts to the statute dealing with doing business with one's agency. The first part of the statute prohibits a public officer from purchasing services for his own agency from a business in which he's an officer, director, or has a material interest. In this case, the city council member in question is providing services to the school board and not to the city council. And we determined that the city council is his agency. Therefore, the prohibition in the first part of the doing business with one's agency statute is not applicable to the situation here. The second part of the prohibition in that statute prohibits a public officer from selling goods or services to his political subdivision or to any agency of his political subdivision. So we had to determine what his political subdivision was in this case. And in order to do that, we reviewed the charter for the Consolidated City Government of Jacksonville and the ordinances for the City of Jacksonville. As you can see in the draft opinion, there are many references throughout the charter and the Code of Ordinances that relate to the school board. Section 13 of the charter of the City of Jacksonville deals with the school board, and the draft opinion points out a lot of sections of that provision of the charter that deal with the structure of the school board and how the city council members have the authority to redraft, to change the districts that the school board members are elected in, and various other provisions that deal with the school board relationship with the city. So after reviewing all of those sections of the charter and the code, we have concluded that the city of Jacksonville and the school board is but one political subdivision, that the school board is not a separate political subdivision in this case from the city, and it's primarily due again to the consolidated nature of the government over in Jacksonville. So therefore, standing alone, the second part of the doing business with one's agency statute would prevent the city council member from being able to purchase or sell services to the school board. However, Section 112.316 has been used by the commission before in instances like this one to obviate the conflict of interest. And that statute allows, as for public officials to permit them to sell services to their political subdivision where the public officer was not in a position to supervise or regulate the provision of those services or to approve or give recommendations regarding contracts for those services. Here, again, after reviewing the charter and the code for the city of Jacksonville, it is clear that as far as the day-to-day activities of the school board, the city council does not have any supervisory authority over the school board. They don't approve the budget for the school board, and there's no input from the city council to the school board regarding the purchasing of services or entering into contracts for the school board to do business with other entities. Therefore, we believe that it is proper in this particular case to construe Section 112.316 to apply here, because here, again, the council member doesn't have any authority or any sway over any decisions of the school board, and by applying Section 112.316 to this situation, it would allow the council member to sell services to the school board. And then finally, for the reasons set forth in the opinion, we don't believe that the prohibition against contractual or employment relationships would apply to this situation. So therefore, we recommend that you find that there is no prohibited conflict of interest under the first part of Section 112.313.3 or Section 112.313.7a, where the council member of the consolidated government owns a construction company selling services to the local public school board. And we further recommend that while the second part of Section 112.313.3 prohibits a public officer from selling services to his political subdivision, under the circumstances of this opinion, Section 112.316 shields the council member from application of Section 112.313.3 because he had no public responsibilities regarding the business between his company and the school board, and also, like I said, the facts regarding Section 112.313.7a, the conflicting or employment relationships, are not relevant here and therefore are not applicable. So if you have any questions, I'll be happy to answer them.
Thank you, Mr. Knight. Any questions at this point for Mr. Knight? I have some questions, but Commissioner Carson, were you about to ask one?
No, I was about to get out of the way.
That's okay. But at this time, I would suggest that we take a minute just in case you haven't had an opportunity to read Ms. Hodges' response, and then we'll give her the opportunity to speak, and then perhaps field questions from the commission for both. Commissioner Brady.
So, I mean, from what I gather, the memo has relatively little to do with the conclusion, but some concern that in the opinion, you declare it a subdivision of government, and the general counsel for the city of Jacksonville says, we'd really like you not to do that.
That's my reading of it.
Okay. Does that matter?
We'll give them both the opportunity to speak to that. I have an opinion on it. I'll give them the first strike. So, Ms. Hodges, you may make your presentation.
Good morning, Commissioners. As I stated, my name is Lasikia Hodges. I'm the Deputy General Counsel for the City of Jacksonville, Office of General Counsel. I want to first say thank you for allowing us to have this opportunity on behalf of the General Counsel's Office to come and speak to you on this matter. I'd also be remiss if I didn't mention how wonderful your staff is. We've had Ms. Doss come and actually train our elected officials in Jacksonville. Chris Anderson, we talk to almost every day to help navigate some of our ethical concerns within our consolidated government. And then I also want to thank John Knight, who's been absolutely amazing in just trying to extract information, working diligently on this file, and trying to understand a little bit better the nature of the consolidated government of the city of Jacksonville, which is very unique in the state of Florida. So you should have before you the memo that was passed out. And as Commissioner Brady just stated, that is exactly the issue that the General Counsel's Office has. We have over 30 boards and commissions. We have 7 independent authorities. So this opinion has impact not just on the city council member, but impact on all the other officers that are serving within the city of Jacksonville, and it's doing business with our independent authorities. So in the draft opinion, our concern focuses on the second part of subsection 3 of 112.313, which essentially prohibits the council member from privately selling services to his political subdivision or agency thereof that he serves on. As the draft opinion states, and this is the conclusion that our office takes issue with, we first have to determine what is that political subdivision. And there's a conclusion in the opinion that says, we conclude that the City Council Consolidated Government of the City of Jacksonville is a single political subdivision, which includes the school board. If you go through the memorandum, there's several reasons why we take issue with that conclusion. The first reason is the school board is a separate political subdivision, and this has been stated in Florida case law. It's been stated in Attorney General's opinions, and those opinions are outlined inside of the response that's been provided to you. We've had in the case CL State in the 4th DCA holding that under a careful reading of applicable statutes, including Section 1.01 Florida statutes, it leads us to conclude that a school district is a political subdivision. We also have the same thing occurring in Dade County School Board, which states that the Dade County School Board was a political subdivision of the state. We even have a definition in Florida statutes. So wherever we use that term, political subdivision, in the Florida statutes, which would include Chapter 112, Part 3, that term encompasses many classes of entities. The definition of political subdivision includes counties, cities, towns, villages, and special tax school districts, which is exactly what the Duval County School Board is. You recently, actually, in one of your opinions, 15-02, you came to this same conclusion. And that opinion, it was a school teacher who had a separate company, and she wanted to know, could she sell services to her high school or to the district or other districts in that county. And in the analysis that this commission just gave in 2015, you stated that absent the applicability of an exemption, this provision would prohibit you or your company from selling to the high school and to the district or to any other school within the district. And there was a nice footnote there that stated, we find that your agency is the high school and that the district is your political subdivision. And you cited several ethics opinions, and you also cited the Florida statute's definition of political subdivision 1.108 that I just read to you. So we know that a school board can be a political subdivision. We know this, and then, as Mr. Knight pointed out inside of the draft opinion, we do have an article in the city's charter that's particular to the school board. That's Article 13. And that article save certain particularities regarding how the redistricting, as Mr. Knight mentioned, the terms. Other than those things that are expressly stated in Article 13, the school board of Duval County is subject to Florida Statutes Chapter 101, the Education Code, just like every other school board in the state of Florida. The school board is also designated in the charter as a body corporate, but this is also consistent with Florida Statutes 101.40, which designates that the school district has to be designated that way. And so we get to the question of whether or not the school board as a separate political subdivision is included in this term consolidated government. And that's a local question, that's a local charter question that our general counsel, through the city's charter granted by this Florida legislature, was granted the right to interpret the city's charter. And so what I provided to you in the response are the general counsel opinions that are exactly on point with the same question. And those opinions occurred about 2 years after consolidated government, because the same public officials had the very same questions that are being asked today. Does the school board, is that included in this term of consolidated government? And the answer to that is no. If you go through the general counsel's opinions that I attached, this is General Counsel Opinion 274, which is binding legal opinions on the consolidated government and its independent agencies. It explains what this term consolidated government means. And it states that Section 1.01 of the Charter consolidated certain former governments. And that's a critical phrase because former government is actually a fixed group of entities. So that's defined and that's listed. And it says the former governments into a consolidated government. So the nature of the consolidation that Mr. Knight is pointing out is of those existing governments, those former governments that were listed at the time. And those listed governments were consolidated to form into one single body politic and corporate. And those governments are listed, and I listed them inside of the 2-page response, and none of those former governments included the school board. And so we had another general counsel's opinion that came later. That was the exact question of, we had various officials, and in that opinion, that's General Counsel's Opinion 317, it states, this office has on various occasions been requested to interpret the term city of Jacksonville, as employed in various ordinances adopted in the council. These requests for interpretations have centered principally around a determination as to whether independent agencies, or some of them, are included within the quoted terms. It states that the charter of the city of Jacksonville consolidated all the former governments which are specifically listed into a single body politic and corporate. And it also states that in the charter, and we still have this in our current charter, it's a different section under Article 24 back in 1968, now it's 1807, we have a defined terms of what independent agencies mean. And independent agencies include the school board. And at the very end of this opinion, it states, the reasonable conclusion drawn from a reading of the charter as a whole and the opinion of this office is that the terms city of Jacksonville, and consolidated government mean only the former governments, their boards, bodies, and officers, and the offices, departments, and boards of the government established in the charter, while the term independent agencies refer to the independent agencies that are specifically listed in the charter. This interpretation should be applied to the use of the terms in the charter and in the ordinances adopted by the city council. So based on the general counsel opinions, we would be of the opinion, and so our request to this commission would be that we revise the conclusion that's reached on that second part of 112.313 sub 3 to hold that the council members' political subdivision is the consolidated government, which is the city of Jacksonville, which is based on the general counsel's opinions that I just referred to, also based on the state statutes and the definition of what a political subdivision is, as well as the prior opinion that you indicated a school district is a political subdivision when you were making that holding, that we hold that in this case, the council member's political subdivision is the city of Jacksonville. That's where he's serving as an officer, not on the school board, and so therefore there wouldn't be a conflict under the second part of sub 3. Thank you.
Ms. Hodges, I think you explained this, but I just need a little more elementary education on the process that the legislature uses to approve a city charter. Can you give me that fundamental, because all of your general counsel's opinions hinge on that authority. So can you explain to me that initial step?
Right. So the city of Jacksonville's charter was approved by the Florida legislature, and then it had to be like all other charters, and then it had to be approved by the voters. So the voters had to agree to this whole restructuring. And so what occurred in the charter wasn't just this aspect of the consolidation. There was a lot of things that occurred in the charter. It was the establishment of central services, because some of the materials that Mr. Knight provided to you was very pointed that the citizens at that time, they wanted more efficient government. So one of the ways to get more efficient government was to not only consolidate those former governments that were specifically listed, but it was also to have the various other independent authorities cooperating with each other. And so that, hence the notion of this idea of a centralized services. So the services that Mr. Knight is pointing out, all of our independent authorities, not just the school board, all of our independent authorities, the city council, the mayor, the constitutional officers are required to use certain centralized services, one of those being the general counsel's office. And because of that centralized services, I think that's caused less lawsuits that you often get in some of the other counties in Florida, where the cities are suing the counties and the constitutional officers and so forth. So I hope that answers your question.
7.02 says the general counsel can issue binding legal opinions.
Absolutely.
The legislature adopted that by approving the charter.
Exactly. Exactly.
Other questions for Ms. Hodges? Commissioner Norris.
Good morning.
Good morning.
Who employs the school board attorney?
So who employs the school board attorney? Well, the school board's attorney is the general counsel. So the general, yes, of the city of Jacksonville, which is appointed by the mayor and confirmed by the city council.
And so the compensation to the school board attorney, and there's many of them in Jacksonville, right?
Absolutely. We have about 40 lawyers.
Right, and so all of them are employed by the city and they receive their compensation from the city.
That is correct.
And they serve the school board, which is the separate political subdivision.
That is correct.
All right, and you've got a general counsel who interprets your charter.
That is correct.
All right, then why do you need an opinion from the Commission on Ethics for this issue relating to the school board if the general counsel is your interpreter of the charter? Because if it's the position of it seems to me that if it's the position of the city of Jacksonville that the school board is a separate political subdivision that is not included in the consolidation, then it seems to me that's an issue for the general counsel to render the opinion rather than the Commission on Ethics.
Right. So through the chair to Commissioner Norris, the issue before us is actually one of state law. It's the ethics laws, which actually this body is the only body by state statute that can make a ruling on that. And so it would be insufficient. The general counsel has to adhere to all the other laws, of course, that are out there. And so it would be insufficient for the general counsel to issue an opinion when that opinion isn't going to be binding on your determination as to whether or not this council member is in violation of Part 3 of 112.
I like your answer to that, but it still seems to me to still beg the question. The issue is you've got a city councilman, right, and you're saying under the charter, if I understand correctly, right, I mean, clearly the city councilman's construction company cannot do business with the city council.
Absolutely.
With the city, okay?
That is
right?
correct.
So this all hinges on the school district being somehow independent agency as the city likes to call them, or a separate political subdivision, depending on, you know, where we're looking. It requires that to be separate. And I don't see, and so if the general counsel under the charter is determining that under the charter these are separate, I appreciate your position with regard, you know, state law on an ethics question, but it seems like to me if the central issue to you is this is a separate entity, then I don't see why you need to talk to us.
So through the chair, this is a determination, well, through the chair. So the first reason why we need to talk to you is because we don't want our client to be in violation of the second part of sub 3, right? And so only this body can make a determination on that point. Only this body can determine the same way you did in the ethics opinion 15-02 as to who's the political subdivision. So through the chair, to Commissioner Norris, we're here before you today because we're looking for you to answer that question. And we're trying to give you some guidance on that question. And in answering that question, you have to determine what is the political subdivision. And your staff has pointed to several provisions in the city's charter to reach a conclusion that the council member's political subdivision includes the school board. And through our expertise, we're offering, just for consideration, the information as to what the terms in the charter mean.
The fact that they share the same lawyer, Commissioner Norris, makes it seem to me like they're more fused. I've gone back and forth.
Right, I mean, with great respect to our deputy city council, it just seems like to me, well, we're independent when we want to be, and then we're not when we don't, and so I'm not sure this isn't just a little editing issue with respect to the commission advisory opinion as opposed to something that's terribly substantive here. And again, it just seems to me that if under the city charter it's determined, and the general counsel of the city determines what under the city charter, then if the school board is considered to be separate, then the school board is considered to be separate. And that seems to me to be your central issue,
Right.
Because at that point, it's a fait accompli that there's not a conflict.
So through the chair, if I could offer that as an edit to the opinion, to revise the language that I read that stated that the consolidated government includes the school board. If we could revise that to state that the consolidated government, based on the general counsel's opinions that I've just provided, and also based on your prior opinions in determining what's a political subdivision, if we could revise that, that would be my request.
Madam Chairman, may I ask one more question?
Yes.
And to our general counsel and deputy general counsel, have I lost my mind here? I mean,
Oh, can I answer?
The chairman draws her conclusions outside of the commission.
If I might, through the chair, to Commissioner Norris. Personally, in a legal sense, I have a little discomfort with the general counsel being able to kind of be a shadow legislature and determine what is and isn't a political subdivision by their view. And if you take a look at the Constitution, Article 8, Section 6E of the Florida Constitution, which is 1968, is subsequently revised and amended, which brings forward the 1885 constitutional provision about the city of Jacksonville. It refers to various type governments being able to be brought together into one thing. And I think that really what we have here is the phrase independent agency, I would not believe to be synonymous with political subdivision. And the opinion that the council cited, 15-2, came from what I would call a conventional county structure, another county, not Jacksonville, Duval County, but rather a county where clearly you have a separate school district, a separate cities, separate county government. And the notion of an independent agency is what gets you to the final result here of there being no conflict. Because the reality of this person's situation is separate enough that they have no actual conflict the way the opinion is drafted. Because they don't, the city council really has nothing to do with this purchasing. And that's happened in other opinions, like for instance, the one where the supervisor of elections needed to rent space for part of their election activities, and they rented it from the property appraiser's private company in the same county. They were all in the same political subdivision. But there ultimately was no conflict because the property appraiser had nothing to do with the purchasing decisions of the supervisor of elections or the rental decisions. Similarly here, this person and the city council don't make the purchases. It is the school board that does it. Now,
Mr. Anderson, can I interrupt you there?
Yes.
Simply because I won't have this thought by the time you're finished. Is it possible then that we could stop our analysis there in the opinion, and I know Mr. Knight would like to speak to this as well, that we just stop it where you just stopped it without addressing the political subdivision issue?
Chair Anchors, certainly that would be one way to write this opinion. You could just not go through the elements of the statutes and say that they're on their face present, but nevertheless they're negated by the factual reality under 112.316. You could just go and say that there actually is no conflict here under 112.316 without going through the elements of the statute and applying an affirmative defense, so to speak. You could do that. I think it is more understandable and a more workmanlike, if you will, to do it the way that it is drafted. But what you suggested is it would be a fine result also. I think the danger of saying that the school board here, which I have seen no reference in any materials to anything saying school district. The words are school board in the situation that you have in Jacksonville and Duval County. And the default definition of political subdivision includes the term district, not board. And there's lots of boards that are within one political subdivision in lots of places. But the answer is, yeah, it could be done that way. The danger, though, is that there's not a danger there. The danger would be in saying that the school board is a separate political subdivision under this governmental nomenclature, because then you would never have to worry about whether you had actual input or not to exonerate somebody from a conflict. You would structurally have no conflict, no matter what the realities were, because it would be viewed as a separate political subdivision. And I think that this is a side effect of consolidation. And it's always been curious to me how you have this tremendously long history of a desire to consolidate the government going back 75 or 80 years. And then immediately upon consolidation, you have the resegregation, if you will, into the independent agencies, and that's Jacksonville's business. It is. But and they can do what they want under their charter, and they can have power or not have power in particular parts of their government. But I think that because it is consolidated, it is inescapable that it is one. And therefore, you have to say that at least prima facie you have the element there of the statute, and you have to overcome it through the use of 112.316. But of course, that you could just go straight to 112.316. I know a few meetings ago we had a charter school opinion that had 3 questions in it. The third question being, is a charter school an agency? And what the commission wound up doing was avoiding that question and just giving the answer under the first 2 questions. So certainly that's within your power to do that. I would, though, definitely advise against any finding by this board that the school board in Jacksonville is a separate political subdivision. I just personally don't see it. But I don't see anything wrong with the final result here, and ever how you want to get there I think is fine, but that would be my view.
Thank you, Mr. Anderson. I know there are people jumping out of their seats to speak. I'm going to let Mr. Knight respond first, and then I will come to the commissioners and then back to Ms. Hodges. Yes.
Thank you, Madam Chair. First of all, we do not dispute, or I do not dispute at all, that a in a normal situation such as here in Leon County, a school district is a separate political subdivision from the city of Tallahassee or Leon County. But based upon all the research I've done, I believe the situation in Jacksonville is different. The city charter that was approved in 1967 by the legislature and approved by the voters, not only brought together all those different governments that Ms. Hodges talked about, but also brought together all the different functions of the city and the county under one structure. The sheriff, the property appraiser, the tax collector, and the school board. And like I said, the school board is under section 13 of the charter. And then, if I can just point out two things. Section 7.02 of the charter, the one that we've been kind of talking about, that gives the general counsel the authority to issue opinions. The first sentence of that section says, the head of the office of general counsel shall be the general counsel who shall be the chief legal officer for the entire consolidated government, including its independent agencies. That, to me, pretty clearly says, under the charter, that the independent agencies are part of the consolidated government. And then, when you go to the website for the city of Jacksonville, they have a link on the website to the offices/agencies of your city government. And there is a list of all the offices/agencies of your city government. And one of them is the Duval County School Board. So I believe that practically under the charter and practically the way the city treats itself, they are one political subdivision that has brought together all these different things under one roof. And therefore, it's inescapable that it's one political subdivision. But like we've said, in this case, you apply section 112.316 because of the facts here to finally conclude that there is not a conflict. But I don't believe there's any way to conclude that the school board and the city are separate political subdivisions.
Thank you. Ms. Hodges.
Okay, so through the chair, and I appreciate those comments, but I just wanted to remind you of a few facts that were not in the draft opinion, but was in my initial inquiry opinion to this commission. And one is, I don't want us to get so focused on the name of this entity, because it's really the substance. Of all of the independent authorities in the consolidated government, the school board is the most independent. It's its own taxing district. Okay, so the legislature allows the school board to levy taxes just like the school board in Leon County and all the other counties in Florida. The school board has elected officials. The city council never reviews the school board's budget. Okay, so the substance of the school board, the only difference between the school board and the other school boards in the other counties in the state of Florida is that this school board, pursuant to the voters of the city of Jacksonville, they were trying to consolidate certain former governments, but they were also trying to make government more efficient. And so in making government more efficient, it made more sense to the voters of that day and still to the voters today, because it's been working out well for the past 40 plus years. You had centralized services, one of which is the general counsel's office. So it's called the school board, but it's a body corporate. That's in the charter, as it is also designated the same way as all of the other school districts are designated as body corporates. And in substance, it's the same. It's completely independent, and the city council save a few things, such as our inspector general that was just passed via referendum, save that, and the general counsel's office. Those are the only services that the school board is really engaging with the consolidated government. And so I wanted to point that out. And again, you know, the language in the charter is very clear about this concept. I mean, this is section 1.01 of the charter, and it lists the county government of Duval County, the municipal governments of the city of Jacksonville, the Duval County Air Improvement Authority, the East Duval County Mosquito Control District, the Northeast Duval County Mosquito Control District, and all bodies, boards, and officers thereof were and are consolidated into a single body politic and corporate. So that's the wording in the charter. And then you have these statutory creatures that are created by the Florida legislature, not created by the city council, created by the Florida legislature. And so that's the difference with our independent agencies. That's the difference.
Thank you, Ms. Hodges. Questions for Mrs. Hodges?
I have a question.
Commissioner Kuhn.
If we remove the language that identifies it as one entity, like how Madam Chair explained, the Chair explained to remove that, is that sufficient for you?
Through the chair to Commissioner Kuhn, that's certainly better, and I'll take it. If that's what this commission is going to offer, I'll take it. But in a perfect world, I'd like you to find that the council member's political subdivision is the consolidated government, which is what I just read pursuant to section 101 of the charter that the Florida legislature passed. So.
Thank you, Ms. Hodges. Any other questions? Very good job responding. Thank you. Thank you, Mr.
Thank you.
Knight.
Thank you very much.
Anderson. At this time, I would entertain a motion and further discussion on the draft opinion.
Move to approve the draft opinion.
It's been moved to approve the draft opinion. Is there a second? Hearing none, the motion fails. Is there another motion? Commissioner Brady?
Can I ask
You may.
a highly speculative legal question? Can we conceive of any damage that would occur as a consequence of the opinion of the Ethics Commission saying that the school board was in the same political subdivision as the consolidated government? I mean, at least as I understand all the stuff, in terms of the opinion, it really doesn't make a difference. The person doesn't have a conflict of interest. Just went through a different path to get her there, and it's somewhat clear that the general counsel of the city of Consolidated City of Jacksonville really, really, really doesn't want you to say it's a single political subdivision, and being a social worker, not an attorney, I don't understand what the damage is. And maybe it's just highly speculative, and we'd like it this way, and we think it goes this way, and it's really has no real meaning in the real world.
I'll let Mr. Anderson respond. My initial response, though, would be just like Ms. Hodges did today. One of you will be here in 2 years when someone holds up this opinion from March 9th of 2018 and says 2 years ago you did this without necessarily appreciating the impact that it had analytically on future factual situations. Mr. Anderson.
Thank you, Chair Akers. Through the chair, let me make sure I understand. You were saying what harm would occur if the Commission on Ethics says that it all is within one political subdivision?
Is there an unintended consequence that I'm just not smart enough to understand?
Well, the draft opinion does find that it is one political subdivision, and that creates a stricter ability to enforce the ethics laws than if you say that the school board is a separate political subdivision. I think the danger is the other way. If you say the school board is a separate political subdivision because it is a, quote, independent agency, then you've got all kinds of other independent agencies within that consolidated government that then could look to that for precedent or reasoning and say, look, we're an independent agency also. And some of them may not be nearly as independent as the school board, and their officials and their functions may not be nearly as independent from the purchasing as is the case in this particular situation. If you go with the draft, you'll have the ability in the future for the city to bring more questions to you on particular officials' situations and their lack of involvement or their involvement that would either create an actual conflict for them or lack of an actual conflict. I really have a problem with, because if you said that an independent agency within this government is a separate political subdivision, then it wouldn't be not very far to say then that the Leon County property appraiser is a separate political subdivision from the Leon County Supervisor of Elections, and we know that can't be. And so the legislature has written the law to presumptively capture within conflicts people that are in the same political subdivision. And then it's up to them on their individual realities, which I think has been immensely shown here as to this person, that they do or don't have a problem. And to paint with a broad brush that the school board in this consolidated government is a separate political subdivision and therefore forego the need for persons to come to you to have their individual situations examined would, I think, not be good on the ethics front. It would make life much more convenient for folks in the city of Jacksonville and in dealing with their officials and giving them advice, and I feel for them on that front. But I think that your job is examining actual conflicts under the language of the prohibitions that the legislature has enacted. And one of the backdoor ways, if you will, that the ethics code is amended is that substantive laws out there in the world get changed. The meaning of contractual relationship could get changed by a statute or by a court decision. The meaning of political subdivision can get fused factually in a given context to where you don't have many, you just have one. And I would urge you not to make any statement that this school board is a separate political subdivision. I would urge you either to adopt the opinion as drafted or to just go straight to 112.316 and forego any discussion about whether it is or isn't a separate political subdivision, and just say under the facts of this particular person's situation, due to the fact that the city council has nothing to do with this purchasing that the school district's going to do from his company, that he's not an actor in his public capacity and therefore he has no conflict. But to separate them out in view of the history of consolidation and the side effects that could render in the future, I would advise against that.
So in my family, we have a phrase about going ostrich. We don't always recommend it, but for those of you who know the ostrich, he buries his head down in the dirt to avoid certain problems. And so personally, my approach on this, but I'm not going to make a motion, I'll defer to the other commissioners, is that we go ostrich with respect to the political subdivision analysis. And I would consider asking a commissioner whether you want to move that the opinion be adopted, finding that there is no conflict of interest with respect to the person providing services to the school board, but to omit the analysis with respect to the political subdivision.
A motion.
Commissioner Kuhn made such a motion, but Commissioner Carson? Is there a second to that motion? We may have to revoke it. Okay. Moved and seconded. Commissioner Carson.
Thank you, Madam Chair. I don't think it's going ostrich. I think it's trying to balance what has been, I think, very eloquently described as the commission's role, the commission's interest, and the city's interest. Commissioner Brady, you asked, what's the harm? I can tell you what the harm is. The harm is a body, and I don't mean to speak for the city, but speaking generally, an independent agency, body corporate can sue and be sued. And it's, I'm pretty sure the school board, school district of Jacksonville handles that portion of their business. In other words, if you've got an issue with the school board, that's where your remedy lies, not the city generally. That would be my big thing. Okay, I'm getting nods. And so I'll say this: I don't know that the Commission on Ethics saying they're one thing for purposes of the ethics law would necessarily mean that if somebody had a legal issue with the school board, they would then sue the city and say, well, look, the Commission on Ethics, unelected, non-Article 3, said that is the same thing. I don't know So I don't look at it and I say all the
I like
time,
that better. I like balance better than ostrich, so I'll take it.
This is an ostrich. This did remind me of the charter one a couple weeks ago or a couple meetings ago where, you know, you can't just say, you know, charter schools and public school, if I recall, that was the main issue. Not because it meant anything to the Commission on Ethics, but because that is a line that has been drawn. And we don't want to, even if it's limited to ethics opinions, we don't want to be somebody who's trying to flirt. That's what I understood the issue 2 meetings ago to be on that. That's what I understand the issue here to be. So, I believe it's moved. I second it. I think for that reason, I would be voting. I don't know that we want to edit it on the fly. My only
No.
suggestion would be to have if that is the feeling of the commission, have an amendment presented next or something.
And the only consequence of that is delay, is that we wouldn't have it until the next meeting. But I agree that it was inherent, at least in my understanding of the motion, that we would revise, the staff would have the opportunity to revise it. Other discussion on the motion? Commissioner Cox.
I just want to be clear here. So, always struggle with these things because I'm not an attorney, right? So, but I certainly respect the ability for a city to have home rule. And when I read this, I came to the same conclusion. There's no conflict there. So, I think that's where I understand this motion to go, is that we're saying there's not a conflict, but we're not going to stick our nose into Jacksonville's ability to self-govern. Is that right?
I would say that's one way of saying it.
Okay, okay.
It's kind of like everything else. It may not be for exactly those reasons. It may be because we just don't want to opine on that definition.
So the motion is to reject the staff analysis or the staff opinion, ask them to rewrite the opinion not to reflect the political subdivision issue, and then bring it back at the next meeting?
Yes, but only rejecting that portion of the analysis that dealt with the political subdivision, not with the rest of the analysis. Mr. Anderson.
Thank you, Chair Ankers. You know, I hate to be rejected. I mean, but you certainly.
Yeah, that's why, that was Commissioner Brady. I think I said adopted, except.
I would respectfully ask that it be in the nature of the matter being continued for further drafting based on your comments today. And I would also like to ask that, you know, there's two statutes, two prohibitions that were at issue here, 112.313.7A, which is agency specific, where really the elements were not there, and 112.313 subsection 3, which is the one that's had the big discussion where the elements were there, but we applied 112.316 as a balm, if you will, to salve the irritation or lack thereof. But would you desire the new thing that comes back in front of you to not even discuss 7A at all, or just to go straight to 316 for the whole thing and describe his lack of involvement and say, therefore, under 112.316, we don't have a problem? Or would you like it to go as to 7A as it is? Do you have any detail on that or not?
Ms. Doss says we don't. My suggestion is that if Commissioner Kuhn and Commissioner Carson would consider withdrawing the original motion and instead consider substituting motion to continue this matter and allow the staff to redraft it based on today's comments, that you will have the opportunity to sort of hash out without us giving you that detail right now, that might be the most expedient way to handle this and leave the most latitude for the redraft.
Can I withdraw my second?
Yes, you may.
I withdraw my motion.
Would anybody like to enter a substitute motion to continue the matter and allow the staff for the redrafting?
So moved.
Second.
It's been moved and seconded. Is there any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Thank you, Ms. Hodges. Thank you, Mr. Knight, Mr. Anderson, and Ms. Doss, and all of the commissioners for careful consideration of those legal issues, especially from the good non-lawyers who had a lot to contribute, actually.
Like the lawyers aren't struggling.
Yeah, it's legitimate consternation there.
I'll need a title on
File number 2712 is the next step for consideration. This file draft opinion will be presented by Betsy Daly. Is the requester here? No. Ms. Daly? Yeah, we got it done. Even if you did have any comments, I'm not sure we. Ms. Daly.
Thank you. This opinion also concerns a public officer proposing to sell something to his Jacksonville agency. It does not, as far as I know, concern the same issue that you just discussed. This opinion was requested by City of Jacksonville ethics officer on behalf of a sheriff's deputy who co-owns with his father a company selling equipment to law enforcement agencies. The officer's company offers a particular type of badge holder he would like to offer for sale to the Jacksonville Sheriff's Office. The draft opinion finds that this plan to sell a product to the officer's agency, the Sheriff's Office, potentially would violate two Code of Ethics provisions. First, the prohibited sales to the deputy's own agency, and second, a prohibited conflict created by a contractual relationship with his private company, which would be doing business with the Sheriff's Office. However, the draft opinion finds that this proposed transaction can meet the sole source exemption. The opinion requester explained that this particular badge holder frames a law enforcement identification badge made of bright neon yellow plastic to provide high visibility whenever visibility might be needed for the personal safety of an undercover officer or off-duty officer. She explained that this particular type of high visibility badge holder is available nowhere else in the consolidated city of Jacksonville, Duval County, and that the deputy's company is the sole source of supply of this item in that political subdivision. Based on this information, the draft opinion concludes that if the Sheriff's Department determines this particular badge holder is the only such product that meets its needs, the statutory conflict exemption for a sole source of supply would negate the two ethics violations of selling to one's agency and engaging in a conflicting contractual relationship. The draft opinion is offered for your consideration, and I would be glad to address any questions.
Thank you, Ms. Daly. Are there any questions? Commissioner
Yes.
Berger.
If a substantially similar product comes on the market, because my understanding is that your opinion is based on the sole, it being the sole source.
Right.
How does that affect your opinion?
If it comes on the market later?
Yeah, if there's a badge that's substantially similar that's out there, whether in Jacksonville or anywhere, how does that affect your opinion?
Well, then I think it would have to be reconsidered, and if the sheriff's office, if it came to their attention, or if there was an occasion to consider it, they would have to refrain from selling it. The opinion doesn't say that, but that's kind of implied.
Madam Chair?
Commissioner Kuhn.
I have a question about the necessity of the badge. Just thinking that, okay, if they're the only ones that are offering, is this something that they really need or they want? Because couldn't anyone come up with the product and be the sole provider of that product, and the Sheriff's Department say that's something we really need?
Well, it's up to the Sheriff's Department to determine that, and we say that in the opinion. So it only applies if they determine it's this particular one is the only one that they need. There are a lot of opinions, or quite a few opinions, related to this particular provision, and they're pretty specific on the facts of each one.
Mr. Anderson, did you still have a comment?
Yes, Chair Akers, thank you. On the sole source opinions, there's sort of been like two threads of decision on that. One is when something is like you mentioned through the chair, Commissioner Berger, substantially similar product. Some things are just inherently substantially similar so that they could like never be a sole source, like a blue Ford tractor versus a green John Deere tractor, that kind of thing. But also there is within your decisional history the notion that there is great latitude in an agency to determine specifically what it needs. And if the agency has objective reasons and they've done a good faith determination that only this product will work and this is the one we want, then that has been a great factor in whether or not it's a sole source. That goes to real estate, it goes to chattel items also, and you don't want to have a mockery of that, and you don't want to have a sham, but then that would involve, like a misuse of public position if somebody did that. But there is great deference to, the substantially similar product is often within what the agency thinks they need.
It's Mr. Anderson. Commissioner Brady.
Through the as part of in the purchasing authority, take the position that part of the sole source criteria is that we only want to buy things made in Jacksonville.
Through the chair, I don't recall that sort of thing,
Okay.
having, that's awfully subjective, and that's sort of an economic thing, Commerce Clause notwithstanding, what you could do on that. It's usually more of a reality thing. Like, I cannot imagine that a sheriff's office could say that a 9mm pistol is a sole source when there's 20 manufacturers. But with this sort of thing here, there might very well be, they're fitting that there are characteristics of this thing and this thing only, and we want it.
Commissioner Carson. Any other questions or comments?
Move to adopt the opinion as written.
It's been moved and seconded to adopt the opinion as written. Any discussion? All those in favor, please indicate by saying aye.
Aye.
Any opposed? Motion passes and the opinion is adopted as written. Thank you. The next item on our agenda, item 9, is the consideration of financial disclosure appeals. It's my understanding that the respondent, Mr. Jason Nelson, had requested a hearing but is not here. Is that confirmed? Ms. Fulford? He is not here. Okay. So I think that we can consider that item, FD 17-004, along with those matters 1 through 9 in the financial disclosure appeal section in Moss, which Ms. Kuhn, since you're new to the table, we try to take certain things up that can be grouped together at one time, unless someone needs to have one of them removed because they might have a conflict of interest in voting on it, in which case we're happy to take it separately. Is there any reason to take up any of these separately? If not, I would entertain a motion that we consider approving the recommended final orders and Moss.
So moved, Madam Chair.
Is there a second? Any discussion? All those in favor of adopting the recommended orders and adopting them in Moss, please indicate by saying aye.
Aye.
Any opposed? Motion passes, and those recommended orders are adopted. Draft orders is really what they are. The next item, 10, consideration of final orders on financial disclosure where there has been no timely appeal. Let me make sure it's lining up. Is there any?
That's going to be item 10.
Commissioner Cox has moved the approval of the final orders on financial disclosures for fines where there's been no timely appeal and no payment. Is there a second? Any discussion? All those in favor of the motion, please indicate by saying aye. Aye. Any opposed? Motion passes. This time, we have before us, once again, the consideration of financial disclosure requirement for Broward School principals. Would you like to address this, Ms. Stiles?
Yes, I was just taking a deep cleansing breath here. You know from the last meeting where we had a Broward School principal before us who had not filed her financial disclosure and was prosecuted for same. In the course of the prosecution, the advocate, Ms. Miller, was told by the district's general counsel that the school principals did not have the requisite purchasing authority to make them local officers. School principals don't have to file just because they're school principals. They have to have purchasing authority in excess of $20,000 in order to make them local officers required to file. So in December of 2017, Ms. Miller was told by the general counsel that Broward school principals did not have that purchasing authority. She confirmed that information with the school superintendent in early January 2018. In early 2018 is when all of the agency disclosure coordinators, all 1,600 and something of them, prepare their lists where they tell us, the Ethics Commission, who in their agencies have to file financial disclosure. You can imagine my surprise when in February of 2018, the Broward School District turned in its list and who was on it as having been required to file disclosure in 2017, but all of its school principals. Based on the statements of the general counsel and the superintendent in late 2017 and early 2018, those people did not have purchasing authority. They were not local officers, and we cannot have them on the list of persons required to file annual disclosure for 2017. That will expose them to fines, willful prosecutions, etc. I've never had the situation of needing to take people off a list when the agency has put them on that list. But in this case, I do not think we can legally hold those people to an annual filing requirement. And although it will be a tremendous amount of work for Ms. Holmes to do this, because there are more than 100 of them, I feel like we need to take them off the list. I have been in contact with the school district, with the general counsel. She said that they were going to be given purchasing authority and they would provide us with a letter doing that. They did not provide us with a letter, although I have to say I hate to even trouble the Broward School District with any issue at all, but they did not do that. What happened was they sent a letter to their principals saying, good for you, you've now got purchasing authority in excess of $20,000. But they did that in 2018, so they're still not annual filers for 2017. We found out about that because we got confused calls from school principals saying, what the heck is going on here? So we need to take them off. Yes, ma'am.
So is what we would be considering today is simply removing 2017?
Correct. Removing them from the annual filing requirement for calendar year 2017. Did I say that right, Ms. Holmes? Thank you.
Just wanted to make sure that we're limiting it just to that year at this time. I would consider a motion in that regard.
So moved.
Second.
It's been moved and seconded. Is there any discussion? All those in favor of the motion, please indicate by saying aye. Aye. Any opposed? The motion passes. Thank you. That was a gift to all. And back to you, Ms. Doss, for your report and the legislative report at the same time.
I will go with the regular executive director's report first because it's shorter and happier. With respect to the litigation, the Stephen Carter opinion almost beat Ms. Miller back to the office. It came out so fast, per curiam affirmed in that case. Very good job by Ms. Miller and Ms. Daly. In staff news, I think all of you have met our new employee, Stacy France, going to be in financial disclosure back there and doing well so far. On the sad side, one of our investigators has found greener pastures in, of all places, the Department of Children and Families, but I'm not judging. We will miss Roberto Anderson Cordova very much, and we wish him well. On to the legislative report. The short version is, we got nothing that we wanted. We may yet get some things we didn't ask for. There are a few small things. The Construction Licensing Board in Pinellas County is going to have to file financial disclosure. That's passed. I think CRA members are going to have ethics training. There might be a couple of other things in there. The bills I was concerned about, that would give us responsibility for registering people who want to lobby local governments, that would put us in charge of sexual harassment, even between private individuals. I think those don't seem to be doing well. There's always the possibility of resurrection, particularly since the legislature is going into overtime. They were supposed to end today, and I don't know if they'll be in session tomorrow, but it looks like they may end Sunday or possibly Monday. Do I have that right, Carrie? Okay. And I don't know how many bills they're going to take up or if they're going to just work on the budget. But those don't seem to be doing well. A couple of things I think I need to raise with you that are really worrisome to me. And one is something that happened last year and has happened again this year. Ever since 2013, well, let me backtrack. The commission has a long history of saying it would be a conflict of interest if a member of a board represented a client before that board, or if any member of that board member's firm represented clients before that board. It's gone back 20 years at least, maybe 30. The commission has been so firm on this, and it has been such a perennial issue with the legislature, that in this year's legislative recommendations, you specifically put a recommendation that interpretation not be messed around with or relaxed by the legislature. In 2013, there was an amendment to a bill, I think by Senate President Gates, that would have relaxed that standard. He was nice enough to put it in the bill as it went through the committee process, to hear from us, to hear our objections, and ultimately take it out. In 2014, the chair of the Senate Ethics and Elections Committee asked me to come to his office and talk to the person who is behind all this on a conference call and explain our position, and I don't think it came up that year. In 2015, it came up in some kind of, but I can't exactly remember what. Last year, it came up as an amendment on the floor in the last 3 days of session in the Senate, and they tacked that onto a bill, saying, oh no, it would be okay for firm members to appear before a board on which their partner sits. The House didn't like that. They stripped it out and sent it back to the Senate. This year, the same thing happened, but in the House. They tacked on yesterday or the day before, they tacked that onto a House bill that was on third reading, got sent to the Senate. And, there's two problems here. One is the change in the law itself, which unquestionably weakens the conflicts law. And the second is the manner in which it's done, which is to not let it go through the committee process, but to kind of slide it in there when, if we weren't watching extremely carefully, we wouldn't even know what had happened. And then the other, I guess, facet of it is, as soon as I found out about it in the House, I contacted the sponsor of the amendment and his aide. I never heard anything back from them. Then the amendment was withdrawn, and I thought, oh, this is great. They heard that we objected, and no, that's not true. It was withdrawn, and then another amendment did the same thing, but was drafted a little bit better, was substituted in there. So now I've been working very hard, as has Commissioner Carson and Commissioner Cox in the Senate, to try and keep that amendment from getting either attached onto some other bill or that bill from going through the Senate. All of this is to say that, in some cases, I'm really concerned that even though they know the commission has specifically opposed something and considered it a weakness in the law, they move forward anyway. And I really think, and this is my opinion only, I really think that we almost have to get much more aggressive in our lobby. We have very little in our quiver. But what we do have is the sort of moral authority and the righteous indignation. My approach has always been to contact people, to be very nice, be very deferential. I don't go to the press. I don't write letters to the editor. I don't try to get people up there to committee meetings to testify. But I could do all that. I can be as much of a firebrand if you want. And I really think that we do the same things every year, and we get the same things every year. We get, we ask for common sense issues, closing loopholes, meaningful financial disclosure, an attorney's fees scheme that injects some fairness into the process, increased penalties. We get none of that. We get posting Form 6s to our website, which is tremendously time-consuming. We get collections, which we didn't want to do. We wanted Department of Financial Services to do because the CFO is the treasurer of the state of Florida, but they didn't want to do it, and we got collections even though we didn't know anything about it. We get audits of lobbyist compensation reports. You know how agonizing this is. We're spending a lot of buck in human resources and taxpayers' dollars, and we're not getting as much bang as I think we should. In addition, it's my view that these kind of things move us further and further away from our core mission, which is to investigate and report on allegations of breach of the public trust. There was a time when your agendas had 4 things on them: insufficiencies, PC determinations, opinions, and settlements, and final orders. Now you see what they've come to. Lobbyist audits, financial disclosure appeals. All of these things, when your staff is working on those things, they're not working on other things. When I have to redact financial disclosure forms to post them on the website, I have to take investigators to do that. When they're doing that, they're not investigating cases, and we certainly do have plenty of cases to investigate. When we have to call people on the phone to get them to file their disclosure so that they don't get a willful, which is even more, it's less time consuming to call them on the phone and get them to file than it is to do a willful investigation. Again, I'm pulling people, lawyers aren't doing the lawyer stuff, investigators aren't doing the investigator stuff. And so I feel like, we're in danger, if we're not already there, of having our scope of authority expanded to the point where it cripples our ability to perform our core mission. And I can tell you, the things that came up this year are going to come back next year. If we're put in charge of registering everybody who wants to lobby every local government entity, in the last 2 years when they've tried to suggest that, they haven't given us any money or any staff to do that. That's going to be something that drains resources from investigations. If we're put in charge of monitoring sexual harassment, and I don't want anybody to think I'm in favor of sexual harassment, I'm certainly not, but we've got a perfectly good Human Relations Commission right up on Appalachia Parkway, and it's not clear to me in any way, shape, or form why they would want to give that responsibility to the Ethics Commission when sexual harassment sounds in discrimination law, and that is not our bailiwick. Nobody on this staff knows anything about that. So all of this to say, my personal opinion is that we need to get a lot more aggressive and make a lot more noise about why these things are bad, and why the Ethics Commission is not the right place for certain things, and why the Commission's recommendations should be given consideration rather than these ideas that I don't even know who they come from.
Thank you, Ms. Doss. Thank you to Commissioner Cox and Commissioner Carson for your individual efforts on behalf of ethics issues. It's really not just on behalf of the Commission. Any other comments or responses at this time to Mrs. Doss' concerns? Commissioner Brady.
There hasn't been any changes by if I understand, the Constitutional Revision Committee has kind of finished the initial drafting, is now going through the public hearings to go for a reduction. There hasn't been any discussion of the role of the Commission on Ethics in the Constitution?
Actually, there has. The Constitution Revision Commission has included a provision that mandates the Code of Ethics prohibit public officers and employees from abusing their positions to obtain a disproportionate benefit for themselves, their spouses, children, employers, or business entities. And it gives the Commission the power to define disproportionate benefit and to prescribe the requisite intent, if any, and to prescribe penalties. So they have proposed extremely broad authority for the Commission, extremely broad. And they have expressed a great deal of confidence in the Commission. So I don't know. I mean, that's a pretty broad grant of authority, but they have really expressed a lot of confidence in this agency.
Any other comments? Commissioner Carson.
Sure, thank you. Comments directly on what Executive Director Doss just mentioned. As it relates to the legislature continuing to try to find homes, agency homes for solutions to problems that they've identified, I don't have any suggested remedy for that. I know that Executive Director Doss has expressed to them these things. It just appears to be falling on deaf ears. And I don't suspect that's unique to the Commission on Ethics or the Commission on Ethics staff. I suspect that that's common. They've identified a problem, they've come up with a solution, they've decided this is who's going to do it. And I'm not sure that it's always whoever's the best fit for it. Sometimes there's other considerations at play. I think we're seeing that, whatever they say, why don't you guys handle this, why don't you guys handle that? But as it relates to the first thing Ms. Doss mentioned, which was we've historically played nice. We've historically respected the process, spoken to members, spoken to leadership, spoken to legislative staff, when in reality, and this is me speaking personally, this attack's a strong word, this attempt to weaken this prohibition against members of the firm lobbying or representing a client in front of the board, where there's another member of that firm sitting on that board, makes a lot of sense. The prohibition makes a lot of sense. And I think, as if it wasn't clear from Ms. Doss's presentation, the weakening, or the attempt to weaken it, is being done, I believe, with a specific strategy in mind, which is if you bring it up on day one, there's 60 days for somebody to say, well, wait a minute, what good does that serve? How are the citizens of the state of Florida, or the residents of this area, this county, or this city, how do they benefit from this? And the answer is likely they don't. You can look at it a couple ways. One is, well, and this is maybe the most benign way to look at this weekend. Well, you're not ruling firms out completely, right? If a member of a firm is sitting on a board, then you're not ruling out representation by the whole rest of the board. I get it in small counties, small cities, that's not a minor, a small issue. Similarly, you're not telling people on that board or in that firm, you really don't want one of your members to run for this board or this commission, because then you're going to be conflicted out of representing clients in front of it. Those are probably the more benign. I think, though, our bigger concern, and maybe the more sinister potential motive behind this is, if you've got a member of your firm on the board, then you market yourself as I'm kind of guy on the inside. Even if you don't market yourself in that way, that's certainly, I think, a likely perception. And that's, I think, the main reason we've fought so hard. And so when you've got 60 days to consider that, I gave a 30-second overview. You've got 60 days of a legislative session to consider that. There's lots of opportunity for people to come out and fight it. When you slip it in on the last day, you slip it in on a third amendment to a bill on third reading, spoken with Ms. Doss about this. I don't know what the right answer is either. We don't have the same outside ethics watchdog groups and some of these other types of I don't know the right word, but the example that we spoke about was this First Amendment Foundation. You know, and anytime a public records issue comes out, the first question from any member of the legislature who's on a committee or any member of the legislature when the bill is being discussed on the floor, the first question is, where does the First Amendment Foundation stand on this? They know the answer, they just want it to be part of the discussion. We don't have that type of external, independent ethics watchdog group that would sit there and watch these bills come out, watch these amendments to bills that are being read for the third time on the floor and say, hold on. You know, sending out email blasts, sending out social media, you know, comments saying, this weakens our ethics laws, why is it even being considered? So, I say all that because when I speak to Ms. Doss, the question is what's the right answer for her? What's the right next step for her or for staff? Should we be reaching out to members of the press who really catch everything else, right? If there's any other bill dealing with guns or schools or the budget, the press picks up on it and calls people to task. They don't necessarily do it with something like this. You would think that this would be something they'd be interested in, but you don't see it being picked up. And so the question, and I think it's something that the whole commission should consider, if not now, at some point. Now is probably too late, but at some point, you know, what do we want the role of staff to be in handling this? Because if there are issues that we feel strongly about, this is one that I happen to feel strongly about. How do we best accomplish, you know, part of our statutory duty, which is to keep an eye, to make recommendations related to legislation to the members who legislate. So I put all that out there for consideration because I think it's a far enough step for staff, especially our executive director, that there needs to be buy-in from the full commission.
Thanks, Commissioner Carson. Commissioner Berger.
If how I'm hearing it is that we have had our position since at least 2013 all the way up to present, and this has come across time and time again for at least the last 5 years, and we all accept the notion that if someone of a firm or partners of a firm should be coming up or appearing before their partner in their firm, and we also accept the notion that at the very least this kind of proposal should be vetted properly like any other proposal through the process. And I heard you say it may be too late. I don't know the answer to that question, but why shouldn't we state our vote on our position on this and have a statement as to our position is this issue has come up from 2013 at least to 2018. We have routinely voted against it from 2013 to 18. We can give the why behind voting against it, that people in a firm shouldn't be coming up against their same firm with some kind of insider, or at least the appearance of an insider situation, and that if it were to be addressed, it should be properly run and vetted just like any other proposal on any other piece of legislation. And so what I'm suggesting is that we should come up with a proposal and vote on our proposal. What's the harm in that? If we're not obviously a lobbying group per se. We have people that assist, and obviously our executive director goes and speaks and talks. But if we're all of the same opinion on this subject, this issue, what's wrong with having a united voice on our position?
I'll let you respond first, Ms. Doss. I might back you up.
Well, the commission already has spoken on that and voted on it. It's in your legislative recommendations for the very reason that it keeps coming back and back and back. So we sort of have that already, and the question is, what would you like me to do with that? Would you like me to send that to the press and say this is what's happening and the commission doesn't like it? Would you like me to just confine myself to speaking with members of the legislature and their aides, or, I mean, how much do you want to unleash the Kraken? I guess is the question.
Commissioner Cox.
Thank you, Madam Chair. So, this whole process over the last several months has really been a wasted exercise. We fulfilled our obligation to propose changes in legislation. So we fulfilled our duty there. We decided to take a step further and to try to advocate for those things that we feel very strongly about, that we all put down in writing and made the legislature aware. I personally have had meetings. Mr. Carson's had meetings. Carrie and Valendia have had meetings beyond meetings, right? So we've tried about everything that we can, and I think we've been very respectful of the process. Unfortunately, the process sometimes gets hijacked by folks that have alternative motives, and I think that is something that we need to address. And how do we do that? I do think that making a public statement is probably more the way to go, and to let the reporting agencies know where the commission stands on these issues. I think that might get us some traction, although I will tell you that on a local level, the press used to sort of keep everybody in line. And I think that there was a fear that if you went into a gray area, the press would at least make the public aware that you were stepping into a gray area. And, I can tell you that from personal experience. I mean, something I thought might have been a really good idea on Monday, I might read an editorial about it on Wednesday and think a little bit differently of my opinion. Those forces really don't exist much anymore. They do on the state level on big issues, on big sensational issues. But on something like this that several years ago might have gotten more attention, it just doesn't anymore. And so in the darkness of night, they sneak these amendments onto these bills that help benefit themselves, which we believe is bad public policy. So the only way I know that we can combat it is for us to take a more public position on something. I'd much rather it be on a positive thing, advocating for something as opposed to opposing something. But unfortunately, we're being dealt a certain set of cards here. We have to play them. And unfortunately, it passed the House. And I personally contacted the Speaker about it, and I've personally contacted Senator about it to try to stop it. And hopefully it does not make any traction in the Senate, and it doesn't go anywhere. But my fear is it probably will.
Commissioner Berger.
On this issue that we're discussing, what I'm hearing is a united historic front across the board to try to protect the public from this sort of type of thing. So I don't see any harm. I actually see some value in having that statement public. I just do, including continuing what Commissioner Cox, Commissioner Carson, and our executive director have been doing. That's just my take.
If there are no other comments, I'm going to offer 4 categories that we might be able to identify and pursue. Some may work better than others, but with a little bit of time, at least I would like to do a little bit of my own homework and brainstorming about some of the more specific ways that we can be effective. With respect to the media as category 1, there's the mainstream, an overused term these days it feels like, but the traditional media that you do not necessarily control or impact and may not be communicating the message that we seek. That is why social media has become so effective, is because it allows new people into the media marketplace to discuss ideas. The question would be, who would be the coordinator of social media, and is it appropriate for the Ethics Commission staff or members to be advocating on social media? I don't think that we should have that discussion today. I would just put it on an agenda for things for us to consider privately and perhaps as staff, and find whether or not that is meaningful and appropriate. The second category I would say is with respect to staff. And then my subcategories under that would be ways that we increase not only the number of staff that are devoted to a portion of lobbying, that might not just be at Carrie or just be of Lindy, but it might include others who have the ability to communicate so that we make a wider swath with the members. Again, may not be meaningful, may not be appropriate, but I think it's worth exploring. So not only the number, but the amount of time, in addition to all the other time you've explained that they're spending on duties that were not originally within their mission, but this may be worth kind of doing some reprioritizing, at least for a temporary period of time during the session. The third category I would consider is individual advocacy by commission members beyond what our 2 appointed ones have done. Just for the benefit of those who haven't been here before, we've been careful to avoid sunshine law violations, to not have all of us operating, but with some more effort, there is probably a way that more of us could be involved in individual advocacy with those with whom we have relationships. I would also suggest that we add to that team of warriors, past commission members, who have an interest in this, but just don't happen to be on the commission right now, who maintain a very strong passion about these issues. And I think we have another source in people that appear before us regularly. I can name names, but I won't this morning, the people who presented to this commission today, who would be very effective communicating on behalf of the Ethics Commission's interest in these issues, not on behalf of particular clients, but on behalf of their interest in how these public policy matters are addressed. So I think they're another resource that we might consider reaching out to where we haven't before. And then fourthly, to explore what Commissioner Carson mentioned about external organizations. And I, again, don't think today's the right day to identify the ones that are out there that we may have a common interest with, but they may exist. They may consider, with a little attention to this, whether they would expand their own mission to include advocacy on these issues. They may not, but I think it's worth a little bit more effort to be able to come back to this commission and report about whether they are another tool that we could use. So those are my suggestions that, once again, I have the pleasure of dumping on very competent staff, but those may be some things that we can explore further and bring back at the appropriate time. Commissioner Brady.
I think it's a wonderful idea. And one of the things that would be helpful, I mean, I used to go testify before the delegation meetings on a regular basis. They have them. I would have absolutely no problems with going to the Day delegation, the Broward delegation on South Florida and talking about it. And part of that is for us to kind of get our message clear and shared, or shared and clear, so that when you go talk to guys, you really say, this is what we think is really important, and this is why we think it's important, and that's why we're going to count on that. I don't write a lot of letters to the editor, but if I had kind of a rough draft of what needs to be said, I'd have absolutely no problems at all with writing letters to the editor. And the Herald, I don't think is very good, but I don't think it's terrible either. So I mean, I think there are some things that you could do if we kind of said, here's the plan, let's go forward.
Thank you very much. Those are all really excellent ideas, and my proposal would be to kind of cogitate on those, put something together for discussion, maybe a workshop at one of the upcoming commission meetings, probably before too much longer, even though this session is just ending, people start thinking about bills and whatnot in the summer. And as to the immediate issue with this little kind of slipped-in amendment, this would be my plan, if it's to the commission's liking, would be once I get back to the office, assuming it's not too late for anything, but I think it might not be too late, to let the appropriate people in the Senate know that the commission had a meeting today and was very disturbed at the notion that this was coming up at this time, and retains its very vehement opposition to the change in the law. And then if it's also your pleasure, I'll let Carrie give a call to a couple of her contacts in the press and say, you know, this is happening and it's not the first time. But if you'd like me to hold off on that, I can, whatever you want to do.
Commissioner Norris, and then
What I would ask is, why can we not have the executive director issue a specific press release that references this particular bill, references its attachment at third reading, and references exactly what the commission voted on months ago as its positive position of support of this, and get it to the fourth branch of government.
is there any objection to Commissioner Norris's suggestion?
I was going to make similar comments, and I think we ought to do that now.
Right.
You know, it's just out of sheer luck, we happen to be here meeting, you know.
So I suggest that we adjourn this meeting so that Ms. Doss can get to work. We have an executive session following this meeting, but is there anything else to come before this commission in open session?
Nothing from me.
Hearing none, do I hear a motion to adjourn? Second, and no objections. Let's reconvene at 12:05, and this time you might want to set your watches for 11 minutes.
I just want to note that I was on time, I've been great.